The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having any manner of form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw now and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel, or actually, good afternoon. We're happy to have you with us, even if not in person. Our colleague, Judge King, is on the phone, and we'll try to defer to him when he wants to be asking questions. So we're happy to hear argument in our first case, United States versus Johnson. Whenever you're ready, counsel.
Your Honor, may it please the court, this is actually WS versus Daniels. That's what we had listed as the first case.
Oh,
Your Honor.
I think you're right. You are absolutely right. It's a good thing to straighten me out at the very beginning. Here.
Well, I have difficulty arguing that other case, Your Honor.
Well, I don't know, you know.
Thank you, Your Honor. May it please the court. My name is Andrew Lindeman. I represent the appellants and cross appellees Cassandra Daniels, Ursula Best, and the South Carolina Department of Social Services. Your Honor, this case out of a lawsuit that was brought by a former foster care child who resided in a foster care facility run by the Boys Home of the South, which was originally a co-defendant in the case, but settled out during the litigation itself. This case involved federal claims brought under the 14th Amendment under the substantive due process, alleging that both employees of Boys Home as well as employees of the South Carolina Department of Social Services, Ms. Daniels and Ms. Best, failed to protect WS and failed to provide him treatment. The allegations were that he was sexually abused while he was a resident at the Boys Home of the South. This case was ultimately tried to a verdict. The jury returned a verdict on the federal claims against both DSS individual defendants, Ms. Daniels and Ms. Best. They returned a verdict for both actual and punitive damages. They also returned a verdict on the state law gross negligence claim against the Department of Social Services for $400,000. As I indicated, Boys Home of the South had settled out prior to trial, actually during discovery in the case, and ultimately paid a total of $825,000. So one of the issues that arose post-trial was whether or not the defendants, my clients, were entitled to a set-off for the settlement paid by the settling defendant, Boys Home of the South. Ultimately, what the trial judge did was he granted a set-off pro tanto for the $400,000 that was returned against the Department of Social Services on the state law claims. But he found that there was no set-off, or found that set-off would be, quote, not applicable to the Section 1983 case. So our first issue on appeal involves whether or not the defendants, Best and Daniels, were also entitled to a set-off from the settlement paid by the Boys Home of the South. There are two other issues that we have also raised, one regarding the application of the Parrott-Hudson Doctrine, which I'll only touch on briefly because in the interim, since briefing in this case, there has been a decision by a panel of this court finding that the Parrott-Hudson Doctrine does not apply to a substantive due process case.
So you don't, excuse me, counsel, you don't pursue that argument anymore?
I'm reserved the right to, I'm not waiving that argument because there's a likely petition for cert in that case going to the Supreme Court. So I don't want to withdraw or waive my argument on that issue, but I also recognize that there is a panel decision, and I'm happy to discuss it at length.
No, I just want to know your position. Thank you.
I definitely don't want to waive it, Your Honor. And then lastly, there's a number of issues dealing with the attorney's fees award that was made by the district court. So touching on the first issue dealing with the set-off, as I indicated, Judge Coggins did allow for a $400,000 pro tanto set off on the state law claim, but found that the set off under Section 1983 was not applicable, as he put it. His ruling.
He said that 1983 was different. There are policy considerations because it's a civil rights violation, constitutional violation, that he wasn't going to give you the set off. And he had authority for that, did he not?
Well, there's no authority for that within the Fourth Circuit, Judge King. Now, he basically, and it was very brief paragraph that he dealt with that issue. He essentially stated 3 points, all without going into great detail, simply a sentence to each of the points. First of all, he found that the constitutional duties that were owed to WS by Daniels and Best were different than the duties owed by the Boys Home of the South, which we disagree with and believe that we can show differently. He also found that the plaintiff raised different claims with respect to Best and Daniels as compared to the Boys Home of the South. And then lastly, he indicated that allowing a set-off would be inconsistent with a policy of deterrence. Dealing with that last issue first, since that's what you raised, Judge King, I would point out to this court that there is precedent in the Fourth Circuit, a case called Morris versus Bland that was decided in 2016, allowing a set-off in a 1983 case.
You don't mean precedent, you mean there's an unpublished opinion on that subject. It's certainly not precedent.
Well, Judge Wynn, I agree it's unpublished, but it's the only opinion that addresses that issue within the Fourth Circuit.
I want you to hear me clearly. It's not precedent.
Right.
Is at best, perhaps for guidance. This panel does not even have to even look at that opinion if we don't want to. You understand that? I understand it. It may be of good guidance, but I want to make sure you understand it's not precedent.
Sure. I was gonna make the point that it's persuasive, or at least I hope it's persuasive.
You certainly can do that.
but ultimately, there's authority from other circuits as well that have allowed for a set-off from a 1983 claim.
But now you go there. There are some circuits that have held just the opposite, and they're pretty clear doing that. And even when you look at the unpublished opinion here, that opinion didn't even discuss a set-off in a 1983 claim. So, I mean, when you're looking at 1983 type actions, they are fundamentally different from what we're dealing with in the South Carolina type law. And there are ways in which you can look at it, but you've got the Second, the Fifth, and the 10th Circuits that have gone otherwise on it. Point's well taken in terms of there is something out there to that point, but I wanted you to at least to recognize that there's a balancing of opinion out there. And I understand you're trying to persuade us to go in one way as opposed to the other.
That's correct, Your Honor. And ultimately, to the extent that there's a deterrence effect, I mean, obviously a deterrence effect is satisfied by what was returned in this case, a punitive damages award. So ultimately, there's also strong public policy considerations, and we cited the U.S. Supreme Court case in EEOC versus Waffle House, where the Supreme Court stressed that no one should receive a double recovery. So you have that policy consideration at play as well. So in this particular case, clearly WS, through its settlement with Boys Home of the South, recovered in excess of what ultimately the jury in this case, and when it went to trial, determined his damages to be. And that would, I would submit, be an appropriate case for a set-off. There is not any type of violation of the deterrence effect, and in fact, it satisfies, as I indicated, the other aspect of policy, which is preventing a double recovery. I did want to also make the point.
Let's talk about, but if you're focused on Section 1983, Section 1983, you know, what's often lost is how that whole section came about and the purpose of it. I mean, it's clear that Congress, in enacting that, wanted to make sure that the defendants would pay for that wrongdoing of violating someone's constitutional rights under color of law. And that's essentially what the purpose of Section 1983. It's not concerned about double recovery or enrichment or that sort of thing. So when you focus on that policy, as Judge Coggins did here, and as did the three circuits that I mentioned to you, it would seem that if, well, let me make sure. What is our standard of review for on this particular issue?
Standard review is clear error, Your Honor.
Well, and I knew that, but I want to make sure we were in agreement on it. So how do we find clear error in the judge making that decision?
Well, Your Honor, again, it's going to depend on how this court then comes down on whether or not you allow a set-off. And I recognize that Morris v. Bland isn't precedent, but it certainly is certainly persuasive to make that point. And we have the Dion case too, which is a little bit more unusual, but there also was a set-off in a 1983 case in the Dion versus, I believe, City of Baltimore case as well. So there is some, and that, of course, was a published decision, so it is precedent. I did want to make the additional points, however, that the other points that were raised in a conclusory manner by Judge Coggins about the constitutional duties being different, that is not supported, I would submit, by the record. Clearly, the same 14th Amendment claims were asserted against my clients as were asserted against the Boys Home of the South. In addition, there were the same claims. There were the same allegations of damages as well.
Let me ask you a general question there. So the Boys Home of the South settled this. You then bring in the set-off aspect of it. You get $400,000 set-off. You know, I think when you all look at this, it doesn't mean that, I guess, social services goes free on it, because wouldn't there be some sort of indemnity that you would owe to Boys Home? Or, you know, I'm almost wondering why it wouldn't be that they wouldn't be a part of this action, because they paid something you should pay. How did that work out? I mean, do you just pay nothing, and Boys Home paid the $825?
Well, basically, if the full set-off is provided, yes. I mean, because that's what it took to make.
And you owe nothing to Boys Home, even though they paid it, and there's a set-off.
Well,
that doesn't sound right.
We're joint tortfeasors.
I got you.
And so ultimately, if one joint tortfeasor pays,
yes.
and there is no right, of course, of contribution.
I'm familiar with the joint and severable type liability aspect of it. My question is indemnity. Would not Boys Home be entitled to recover that $400,000 from you?
Well, Boys Home in the South would have to show that they had absolutely no culpability and were paying based upon their relationship with the Department of Social Services. And no such claim has been made. And I would submit
I'll let them handle that, but I'll tell you that there's absolutely something wrong with that situation there. And I know that in set-offs dealing with indemnity, even when you have Medicare or other thing, governmental claims, if a joint tortfeasor pays the entire judgment, it doesn't mean that the other one now can walk away and do nothing. He can actually go against the other person, but that's an issue outside of you. I was just curious as to the whole $0 that is being paid by your client. But go ahead.
I see my time is up, Your Honor.
It is up. Would you like to use some of your rebuttal time?
Yes, Your Honor. I have 7 minutes.
Will be used to count against your rebuttal. Okay.
Oh, no, I'll wait for rebuttal, Your Honor.
All right. Thank you.
All right. Thank you.
We'll hear from the other side now. Counsel?
You're muted.
Mr. Butcher, please unmute yourself.
I apologize for that. My name is Robert Butcher. I'm one of the attorneys for WS. Co-counsel Heather Height-Stone and Thomas Height III are watching on YouTube at this time. I appreciate you having us. The first thing I wanted to address is, yes, South Carolina Department of Social Services is getting a windfall with not having to pay anything if the set-off remains. But I do want to address the issue of the set-off. In South Carolina—
But that would not, let me just be clear in terms of my statements on that. That doesn't affect you. If they say the total damage was $800,000 and they just didn't have to pay that 400 because it's set off, you still got 800,000. So that's between them and Boys Home to deal with that little indemnity thing that I was talking about. So I want to be clear. I wasn't saying you should get it under this analysis if the set off is proper.
I understand, sir. But I believe that, well, I do understand that. But what I do want to emphasize is that after we settled with Boys Home in the South, the first bit of discovery, which was sent, and that you can find that at the Joint Appendix 206 and 224, we sent discovery requesting information regarding all of WS's claims that ended up being in the amended complaint. And DSS, they delayed and objected and refused to produce for over a year. And that's part of our issue with the court not allowing us to freely amend. But all of that should be a signal to the court that those are all the injuries. And if you look at South Carolina set-off law, set-off, it allows the defendant a pro tanto reduction of judgment for the same cause of action and the same injuries, correct? And the other thing is, as a matter of law, there's no set-off when a settlement is for a different injury or different claims. So what we have are a small bucket of apples, which was what DSS did, because we were only allowed to try 4 injuries that were in the original complaint.
So I want to admit something. I found your argument very hard to follow. But if I understand you correctly, this is the way I see it. You're saying that the $825,000 settlement figure compensated for dozens of injuries, all kinds of injuries, both pled and unpled, as well as many unrelated claims, and therefore is different than this one that dealt with specific ones. Is that what you're saying?
I am, Your Honor, and here's why. When we took this case—
Did this one deal with 3 incidents? How many were on that $400,000?
It was, well, I would say there's res judicata, and we tried 4 incidents, and we won 3 of them.
You won 3. So the $400,000 recovery that was offset was related to 3 incidents.
Yes, sir. But Your
and the
Honor,
settlement was how many?
But Your Honor, if you remember WS's testimony, he was sexually abused over 100 times by 13 other children, 11 that we could identify where social services had noticed that those children sexually acted out on other children beforehand or were dangerous. And it happened over the whole 3-year period. The dates—
So how many incidents were covered by the settlement?
4, all of them. Remember—
Well, how many? I've asked you that 4 times now.
I'm sorry. 21,
how many?
21, Your Honor. If you look at the amended complaint, it's at JA 1029 through 1131.
21 instances for the settlement and 3 incidences for the verdict. Is that right?
Correct, Your Honor.
So they all said the settlement of $400,000 to 21. Then is that the basis for your claiming that that you want your $400,000 back?
Well, yes, Your Honor. Or the district court could be instructed to equitably identify what Boys Home of the South paid for, and retract, and subtract from that.
So you're saying the set-off wasn't calculated properly?
Yes, sir. There was no calculation. He just, the district court— I'm sorry, sir?
It was a calculation. He said the $400,000 is set off. He came to the figure of $400,000. But you're challenging that, right?
Yes, sir. And we presented the evidence and showed that all these other occurrences happened where WS was sexually abused by these 11 other children over a 3-year period. So the injury—
let me be clear. Are you admitting that the 3 incidents here were covered under that agreement? of the 21, were the 3 here covered?
Oh, yes, sir.
Isn't that your problem? Isn't that your problem? Isn't that your problem? They were covered under that. You just say, and you didn't delineate what amounts were being assigned to each one of them. That agreement doesn't do that. That's just a broad agreement, has a figure, and we don't know how much is assigned to it. And I don't know how the court goes back now and, as you say, equitably decide that this is worth this and this is worth that.
Your Honor, there has to be some mechanism, or as the South Carolina's courts have shown in Hawkins versus Pathology Associates, in cases like that, there is no set-off if you cannot determine the total loss or equitably divide the total loss. And I think
But counsel, I thought you just told us that the 400,000 did represent the total loss. That is, it covered all the incidents.
I misunderstood. It represents the total loss that a jury assigned for those 4 incidents. And
I thought you said it was 3 incidents.
Well, there's res judicata. I mean, they decided there was an incident on in March of 2011, but they found on March 2009, June 2009, and November of 2010. So those 3 incidents, the jury decided was worth 400,000.
Your problem is that you have a settlement agreement with a lump sum. You didn't put specific amounts for each one of them. That's the problem you now have. And now when you're dealing with the set-off, the judge, again, what is our standard review? Clear error. And so when we're looking at that, we've got to discern, what did the judge do here under the circumstances? There's no indication of any dollar amount here. And that's a major problem.
And Your Honor, I think what the courts and even the restatement in Restivo versus Hesseman and Dobson versus Camden say there's no set-off if you can't divide it up, if you cannot determine what the settlement is for. Instead, the judge basically rewrote the contract we had with Boys Home of the South regarding the settlement. And now settlements, you get what you can take. There's very often little parsing. The only time you really see parsing is in a wrongful death where someone tries to shove everything towards survivors so they can get a big verdict on the jury and not have any set off. And then you see the courts rewriting those contracts to say.
Well, I want to ask you a question though regarding, if you will, I know the judges may come back to it, but attorney's fees.
Yes, sir.
The court here found that your billing practice was somewhat concerning. Looked at this so-called block billing, and can you help us as to why the court made this exception for you on this block billing?
I'm not sure. He didn't explain it, Your Honor. And I think what he did was he took the different Kimbrell factors, and I think he just lumped together the different objections DSS had, and he really didn't delineate it in the order to give us some sense of what he was doing. So I think.
So you're telling us we ought to send it back and ask them to do so?
I think that's probably, that's the most logical and fairest thing, I believe. It is what it is. I mean, yes, certainly.
Counsel, do you think there is any possibility in the world that you would get greater fees than you've been awarded?
I certainly believe there should have been enhancement.
That's not what I asked you. We're dealing with the what's happened now. We're looking at it retroactively, but you want us to send us back to the district court to re-award fees.
I guess not. No, Your Honor.
Sounds like to me that's what you just said, and I'm sure the defendant's going to agree with you on that one.
I'll walk backwards on that, but I mean,
you want to leave the fee thing where it is.
Yes, I appreciate that.
That's your position today. You also wanted to amend the complaint and start all over at one point.
Certainly.
Does that mean you're going to give all the money back and the verdict back and start all over?
Well, I think we have res judicata on the two individual defendants under 1983. There's really nothing else we can do with those claims, and there's no reason to try them. They tried them for the specific set
I
of
would think you
facts.
walk back that claim about amendment. You better try to hang on to your verdict.
Oh, boy.
I understand that. I believe if I mean I think the amendment was it kept us from being able to try all the injuries which were set off. And so we didn't have the same.
Well, that's where that goes back to your claim on the set-off. You'd like to have the set-off vacated and reinstated or done over again. Is that what you want?
Right, and I think that reflects South Carolina
You don't
law.
want to have to try all this again, do you?
I don't want to, but I think that would be the fairest thing to WS.
So you're appealing the case where you won. Okay. You're going to give that $850,000 settlement back?
I mean,
And the
try it
attorney-
again?
well, the settlement can't come. I mean, we can't do that again. May I address the 1983 issues as it pertains to set off?
Sure.
I think one of the things, and I didn't really see the big picture until just recently, is if you look at Northwest Airlines versus Transportation Workers Union and Texas Industry versus Radcliffe Materials, those cases, they deal with the Sherman Act, the Clayton Act for Texas Industries, and they deal with Equal Pay Act and Title VII. And that's where 1988A is applied, and it teaches us that there are the three steps. DSS, or the DSS defendants, when they talked about the 1983 set-off, they did step 1 and step 2, which was federal law, or is there federal law? 2, is there state law? And then they skipped test 3. My time is up. May I continue for a minute?
You can continue. It takes up your rebuttal time.
Thank you, ma'am. And when you have the, and DSS didn't even address this issue in their brief, does it conflict against the policy, which you all went to. But I think that's where we get the Fourth Circuit cases, which aren't necessarily 1983 cases, but that's where you're getting the jurisprudence from in Hepburn, Pinchback, Jellin, and Woodson. And that's where that logic comes from, where the court ruled that there is no contribution in those cases, because contribution and set off being very similar, that it is, that it contradicts the congressional purposes. Last thing is with the Morris case, if you look at, I believe Burke, they talk about Big Elk. Big Elk had the same issue as Morris. Morris, in Big Elk, they didn't argue about set off in 1983. And the court said that's not dispositive and it's not applicable here because the circuit court didn't address it. And plus, there's a reason why it's unpublished. Thank you.
Thank you very much. You have some time left for rebuttal. Counsel, do you have rebuttal?
Mr. Linden.
I did the same thing. Thank you, Your Honor. Yes, I do have rebuttal. Your Honor, touching on the set-off issue with respect to the $400,000 on the state law claim, I would call to the court's attention that a couple of points. Number one, the complaint itself alleges the exact same events, and there are 4 different occurrences, 4 different events against both Boys Home and against the DSS. So there is absolutely the same claims that are pled. And
What is the factual basis for them being identical?
Because they're
Because
identical.
he was in the boys' home and your client was supposed to be supervising?
Right. All of the events that are alleged here is while he was a resident of the Boys Home, which was from 2008 to 2011.
Right. Okay.
And then the key language in the release itself, which is at Joint Appendix 2378 and 2379, there are a number of recitals I want to call to your attention because they specifically indicate that what the settlement was for were the claims that were litigated. In fact, the very last recital says, this agreement pertains solely, stressing the word solely, to the claims asserted against BHOTS, Boys Home of the South, defendants in the lawsuit, as the plaintiff expressly reserves the right to continue litigating his claims against SCDSS defendants. And then there's, previous to that, there's additional language that says, the plaintiff has agreed to resolve the claims asserted against Boys Home of the South defendants in the lawsuit pursuant to the terms and conditions set forth below. So this is a bit of a after the fact argument suggesting that there were additional claims that could have been brought and that were settled.
He said there were 21 incidents. He said incidents. He didn't say 21 claims.
Well, there are
21 claims were settled for $850,000, and the verdict $400,000 related to 3 or 4. He was ambiguous on that.
The complaint against Boys Home of the South, Judge King, alleges the same 4 incidents that were asserted against the DSS defendants. In fact, the term
there were some more outside the complaint. He said it was settled 21 incidents, is what he said.
Well, there's nothing that indicates that in the document itself. And as I indicated, the recital says this agreement pertains solely to the claims asserted against Boys Home of the South defendants in the lawsuit.
Well, but the language that you read to us also seems to indicate that there are other claims. This settlement only addresses these. Now, maybe he never pled them, and I don't understand that. But I think that the language you read us gives a clear indication that there are some other claims. Maybe he never pursued them, but they're only willing to be bound by the settlement with respect to the ones that they list. And they make a big deal of that, right?
Yeah, and that's the language in the agreement itself, and that's the language, obviously, that Judge Coggins relied on. And
other claims that that the settlement does not settle? The fact that they're particularly reserving this argument?
Well, there's not an indication in the release that there are other claims being reserved or carved out, Your Honor.
Well, let's be clear. It does say resolves all claims asserted, could have been asserted, or should have been asserted.
That's right. And at the point in time that there was a settlement, of course, the statute of limitations had also run. There could not have realistically been an additional lawsuit that could have been brought at that point in time.
Well, and in any event, there wasn't one.
And there wasn't one.
And you don't need a statute of limitations in order to be able to settle a case. I mean, the statute of limitations could run, you can settle the case. That doesn't apply in a settlement agreement. Well, so it could have been asserted. It could have been asserted. What you're saying, you'd have to bring the affirmative defense of statute of limitation, which I guess any good lawyer is going to do. But my point is the settlement does not kick out those things. It just takes that off the table. So all those that could have been asserted, whether it was statute of limitation or not, you can't even bring them at all.
But the key point, I think, Judge Wynn, is what Judge Coggins looked at, and I believe looked at correctly. And of course, again, the standard review, as you pointed out, is clear error on this, is comparing the actual allegations against Boys Home and against DSS in the complaint, and they are the same.
Now, I want to be clear, just because it seems to me your strongest point is it's a lump sum settlement. It doesn't delineate what the fees are going for at all. And the other side has indicated they are included in there. Those 3 or 4 claims or whatever is included in that settlement, and it settled all of them. So that seems to me set off probably should be given, because if they didn't want it to be set off, they should have delineated what it was. And I think that would be a different case if each one of those had been given an amount, and then your 3 had an amount there. I think it'd be more of a problem for you. But
you're correct that there are not any claims that are specifically delineated in that release.
Well, counsel,
yes.
I may have misunderstood this whole case. We didn't get off to a great start when I called the wrong case, so it maybe not be my day. But I thought the argument of the other sides was that their 1983 claims were different than their state law claims. And that there, and you know, you're an experienced lawyer, that you can have the same factual predicates, but if a statute or a common law duty, for example, gives you different rights or gives you against the other side, you can make those same factual statements be part of this the different arguments, the basis for different arguments. Isn't that so?
Well, the point I was trying to make was to show that as a part of their cross appeal, they're challenging whether or not the $400,000 set off should have been allowed. We believe that that was appropriate. Our argument was also that the judge should have allowed an additional set off for the amount.
I see. We're dealing with a lot of set offs here. Okay.
Right, two different
different set off arguments. Got it.
And real briefly, I see I'm running out of time here. I did want to touch on the attorney's fees issues. Obviously, they're pretty key issues as well. There were a number of problems with the block billing. Judge Wynn pointed out that judge created an exception for these plaintiffs and did not really spell out any basis for that. I believe that's clear.
So what do you think we do? You think we should just send it back on that, just to have the judge explain that part of it?
Well, I think you could send it back on that, but there are other issues that he also didn't address. He didn't address, number one, whether or not there should be a set off, and we relied on the Corder versus Brown case for attorney's fees that were paid under the settlement to Boys Home. He didn't take into account the limited amount of success based upon pretrial negotiations. Where
he cut the fees by a third, didn't he?
He cut the fees by a third, but of course the fees were there were so many hours, and the block billing didn't spell out what exactly they did for these fees. They were 86 days of more than 14 hours a day billed to this case. There were well over 2,000 hours by one lawyer billed to this case. And of course, the block billing didn't allow a determination to be made. Ultimately, there were issues regarding work that was done on the Boys Home the South claim, which obviously my client shouldn't have to pay for. And obviously, there was work done on the state law claims, which doesn't give rise to recovery of attorney's fees. So he did knock off 1/3, but our position is that is not enough given the circumstances, and that there are a number of issues that he simply didn't address.
You can have an extra 1 minute and 43 seconds, but then you used some of your rebuttal time first time around.
Thank you, Your Honor. First, I wanted to address and make sure you understand that we didn't really have a normal client. Our client was between the ages of 8 and 11. And not only that, he had been sexually abused. So we came in with a certain set of facts. And as we progressed in the case and as we gained trust with our client, he told us about the other sexual incidents. That's why when we started the discovery in January 27, you look at those discovery requests and we're asking about all these other boys who had sexually abused him. You don't get everything with these children. They've been harmed, they've repressed things, and they don't have a great memory because they have repressed things.
So you precluded from bringing a separate lawsuit for those?
No, we tried to amend timely against the South Carolina Department of Social Services. DSS, the agency, never raised a statute of limitations argument when we tried to amend.
That's a whole different question. I don't want to get into statute of limitations. Right. I'm just saying you're complaining about you discovered some other incidents and stuff, and I'm asking, does res judicata preclude you from going and dealing with those outside of this?
I think the court can say that it's res judicata on the 4 issues. Well,
I'll let you decide that outside of this, because that's not one of the issues in this case here.
Other incidents?
Yes, sir. If you look at June 14th and 2018, we tried to amend. That's at JA 1011. In the amended complaint, of course, you can find at JA 1027.
Well, you were bringing additional incidents or claims or whatever you call them?
Yes, sir. And we were within the discovery period.
How many were you alleging in your proposed amended complaint?
I believe it would have been 17 new ones in the.
That's where you got the 21. You were going to go. You had 4, and you were going to add 17 more.
Yes, sir.
And it was 9, right?
Correct. And Your Honor.
So you settled when you settled for the $850,000. That was for the 21 incidents included in the complaint and the proposed amended complaint.
Yes, sir.
Well,
and the record supports your saying yes, sir, on that?
Yes, sir. If you look at, and that is why when Boys Home the South settled, they said for everything from 2008, May 2008, all the way to April 2011, they wanted to cover all of that. It's not in evidence what was discussed in settlement, but I think you can once again look at our discovery and look at what we tried to do to show, and that should show and signal to the court that all our claims we tried to prosecute. And so that's why we objected to the judges taking away the $400,000 from DSS, because he didn't try and either itemize, which, you know, how would we have gotten a defendant who was denying liability in the settlement to say, oh, let's go ahead and tack it up to these incidents? I mean, then if you guys say that we should have done that, how is that going to harm settlements in the future as a policy?
what about you doing it?
Yeah, you're going to do a little different next time, aren't you?
If
I mean, that's
can.
kind of, well, no, when it comes to settling a case, you're going to, I mean, it doesn't reflect that you kind of felt, it doesn't reflect that you understood settlement, a set-off could apply to this.
No, we knew a set-off could apply, Your Honor, but we also didn't know how much liability DSS had until, you know, and we still never got all the documents in the case, but we were able to identify 21 incidents where DSS knew about children being dangerous and continued to place our child with him.
So you were expecting a much higher verdict?
Well, no, because we didn't get to try all our claims.
All right.
Because, you know, I mean, we knew that the minute, I mean, DSS, they knew we had these claims, they fought them, but they also knew that the set-off law said if you don't have the same injuries, if one is a large pool of injuries and one's a small pool, that the court either that if they can see something concrete, they can carve out of it.
You didn't reasonably expect a higher verdict than what you got on this for a 10-year-old been raped 3 times in a home, and you've got a supervisory authority there allowing it. You thought it would be $400,000?
Your Honor, it just hurts my ego to say, oh, yeah.
I got that, but I understand it hurts my sense of something, I don't know, to believe that you didn't think you were going to get a higher verdict than that. I don't know what all the evidence was. I didn't go back and read that transcript on it, now I'll tell you that. But I thought that was, well, I'll leave it alone.
Well, we're in South Carolina. But we gave it a shot.
They don't like it in South Carolina either.
Yes, Your Honor. The other thing is, one, Rule 15C, or I'm sorry, under Rule 16, we should have had some comfortable notion that we would have been allowed to amend within the scheduling order. And, you know, the court, they denied us the ability to amend. And
what was the abuse? What's the abuse of discretion by denying it?
Because the Fourth Circuit says that amendment is a mandate.
How many times did the district court give you the opportunity to extend the deadline in the scheduling order?
6 times when we tried to amend. But Your Honor, one of the things, we did not get our motion to compel and get the evidence until just short of our amendment. And I mean, you know, from the time we issued discovery until the time they produced the last bit after the motion to compel, 484 days passed. And we were begging, and you saw the letters that in the emails and the motions where we were begging the court to allow us to to get the discovery so we could amend, and we mentioned it.
When did you make your first motion to compel?
We weren't allowed to file a motion to compel until, I believe it was October of 2009. By then, we'd sent 5 emails to Chambers asking for a discovery conference. And in 2 of the motions amending the scheduling order, we've advised the court that we can't amend till we get the information and the discovery. And DSS.
Let me ask you a question, just make sure I understand what you're asking for.
Yes,
you're
sir.
saying you want us to find that court abuses discretion by not granting your leave to amend. If we give you that, don't we have to require the court to vacate the jury verdicts here along with the attorney fees in this case, given that you prevailed and received an award? Is that really the relief you want?
I think
I mean, how do we get around it? If we go back and say that the abuse discretion by not amended, then we got to vacate the whole thing. Is that where you want to go with this?
I think if
You don't want that, do you?
If the court says that set off was inappropriate under South Carolina law because the injuries were different, I think we'd be willing to forego our amendment arguments.
You're trying to negotiate with Judge Wynn.
That doesn't sound very fair to me. That doesn't sound right to me.
I never heard
you asking us, you asking us pick and choose which one you win in the light most favorable to you. That doesn't work that way. We can't do that. If you come and make an argument says there's abuse discretion amendment, we find that and the setup. We don't come back and say, well, since you're going to be better off with this, we're going to just ignore it. That doesn't work that way.
Thank you, Your Honor. We came here for everything.
I don't think you did. Not if you want that right there. You came here for nothing, it sounds like to me.
Thank you very much.
Thank you.
I think your time has expired. We appreciate your arguments, both of you. And I'm sorry to have called the wrong case to begin with. We'll take the case. If we were in Richmond, as you know, we would be coming down and shaking your hands. But circumstances don't allow it now. But we wish you well. Stay safe. Thank you
very much. And thank you, Mr. Lindeman.
Thank you.
In our second case, the Episcopal Church in South Carolina versus the Church Insurance Company of Vermont. Counsel?
Your Honor, Thomas Tisdale here on behalf of the Episcopal Church in South Carolina, otherwise the diocese, and happy to be here and thank you for the opportunity. Diocese South Carolina, in this case, appellee, is a captive insurance company of the Episcopal Church. The appellant, the Episcopal Church in South Carolina, is a hierarchical church, having been deemed to be so by this court in Dixon versus Edwards in 2000. The appellee, the insurance company of Vermont, insuring any policy of insurance or any insurance to any non-entity of the Episcopal Church, South Carolina.
Are we in agreement that the policy year here is 2012?
No, Your Honor, that's one of the. In fact, the settlement was made on different policies in 2015. So we can't agree that we're here on a 2012. We don't know.
I hadn't picked up that. I thought it was 2012, to be honest.
That's when it began, Your Honor, but it has continued for years since and is going on right now, what we're complaining about. Now,
who owns the policy? Who's the holder?
It's the diocese.
Well, that brings me to another question. We know that there is a group of cases here brought between the two Episcopal entities in South Carolina.
That is correct.
Should this case be held in abeyance because of that litigation?
The Fourth Circuit have been held in abeyance pending a decision of the South Carolina Supreme Court on issues that have followed what it said was its final judgment in this case.
But the South Carolina Supreme Court seems to be not terribly helpful on some of these issues. And is your issue an issue that could be resolved by the South Carolina Supreme Court?
The issue before this court, Your
Yes,
court?
yes.
Uh, uh, we don't think so.
Okay.
May I proceed and just say what our claim is? And I think that will give some help in some of the questions that the court has already raised.
Well, let me at least point you, because we could go into a narrative of it, but I think it would be helpful with regard to those claims. I would say you have the burden of showing jurisdiction. You probably accept that.
Yeah.
And so what I'm asking is, in as straightforward a way as you can for each claim, can you tell me what is your injury in fact, and how is it fairly traceable to the insurance company's conduct?
Well,
that to me seems to be that goes right to the heart of what I think is the issue. But now I'm not speaking for my colleagues, but that's what I think it is.
I think that I can, at least partially, if not completely, satisfy your question by describing the claim we're making. And it is this, that Vermont, the captive insurance company of the Episcopal Church, has and is providing insurance coverage to parties not related to the Episcopal Church, which is prohibited by its charter. And it is reimbursing them, the non-Episcopal entities, for time the Episcopal Church. And they are paying these fees and litigation expenses from the proceeds of insurance policies that are owned by the Episcopal Church in South Carolina, according to the South Carolina Supreme Court. Now,
So they have other insureds that you don't think they should have.
absolutely.
And Judge Gergel said that wasn't any of your business and you didn't have any standing.
Well, Judge Gergel says we didn't have any standing, but we think the procedural law regarding standing is quite relevant here, and that we do have standing to proceed. And if I may, I would cite three important principles on the standing issue that make that so. First of all, this court is required, we believe, to consider the issue de novo. That was affirmed by this court in 2018 in the Deal case, Deal against Mercer County School District. Then all of the factual allegations of the complaint must be accepted as true. And if Judge Gergel had accepted all of the allegations of the complaint as true, we would have standing. That was confirmed by this court in the Broadband Homeowners Association versus Oakland Band in 2013. Now, thirdly, and I think this one is very important, a dismissal for lack of standing, this court has said in 2011 in the City of Charlotte case versus against Benham, that lack of standing is premature before, if it's made, a dismissal for lack of standing is premature before any discovery is taken. We ask
so help me out at least in understanding the structural situation here. You say you're hierarchical, and here you have many entities, I assume, in this hierarchical situation. This is a group that has sort of broken off. And the question is that I have is, in terms of your injury, so you now have an injury, what is the injury, and is it different? Does that injury also exist for those who haven't broken off? In other words, if this insurance company had reimbursed an entity that is not your litigation adversary, would you still have an injury?
We would not, I don't think. But the people.
Well, then why? I mean, so what is the injury? Is the injury here that you are being sued?
No, Your Honor. Here's what it is: the people who have broken away, which locally called breakaways, have are in litigation suing us, claiming that they own all the property we own. And that is a huge amount of property, including diocesan property and parish property.
Isn't that a coverage question as opposed to a duty to defend?
Your Honor, what our claim is that because the Vermont Insurance Company is paying them for suing us, and they are our captive insurance company.
Paying them in the sense of defense.
Yes, the way we found out about this, they've been secretive about it. Vermont has been paying them to sue us by reimbursing all of their legal expenses. Now
so that's what you mean by the paying them. Paying them sort of, to me, is a very broad category. I didn't know if you were saying they were giving the money, and they see a duty to defend, which in most entities is a broader obligation than coverage by far.
Yeah.
And so, and to be able to prove that you have a claim here because is that there's an injury you are suffering here, and is that
this was going on, found out it was going on because it was secretive until 2019, when one of the parishes right here in Charleston said we would have had a budget deficit this year had the Vermont Insurance Company not given us $79,000, which we used to fight the Episcopal Church and its diocese.
Here's the fight now. But I don't want to get into the middle of what the merits of this are. That's not my interest here at all. I'm just trying to get this duty to defend aspect of it. Weren't they defending against claims that you bought against them?
But counterclaims.
But what?
Oh,
there were counterclaims in the case.
Huh.
Your Honor,
So I think the answer is yes.
Here's what happened. They sued us, claiming that they owned all of our property. We counterclaimed back that no, that's not right. But the fact is they have been trying to take our property from the church in a lawsuit that was filed in 2013, and it is still going on.
Well, I just want to be clear that in the discussion of this case, even in the factual, from my perspective, the merits of it and what's going on under the underlying, really, this is a legal issue dealing with insurance type coverage. And that's a whole, I mean, you can make this as much as you want that we'll get in the middle of this fight. We're not in the middle of this South Carolina Supreme Court stuff here. And as Judge Mott says, I'm not sure they won't answer this question too. But the question to us has to do with the insurance company.
Right.
And insurance duty in terms of defense is different than coverage. And that's why I said when you said pay, I was confused with that because I thought you were saying they gave them some money for some damages that were done. You saying no, it's a duty to defend. And that's why that 2012 is a very important time period, isn't it? I mean, I see you backed away from that, but I thought it was pretty clear.
Except it's continued beyond that. What has happened in the claim against Vermont is that what they have done is violated their charter to the detriment of our client, the Episcopal Church in South Carolina. And they have flat out insured entities that are
Have you all complained to the insurance commissioner of Vermont?
We have not, but and another point I should make is that they have no authority to do any business in South Carolina.
Well, so if you complain to the insurance commissioner of South Carolina.
We've complained to everybody we can find in South Carolina.
Well, did you complain to the insurance commissioner of South Carolina, the insurance commissioner of Vermont?
Yes.
Judge Gergel says you can't bring that, you can't sue them in the federal court because you don't have standing to complain about who they're selling insurance to.
Well, we think that Judge Gergel is in error on it because, number one, we haven't had a chance to take any discovery on this to find the depth of the problem. And all of the allegations in our complaint are true, which established that we do have standing. And we just think that Judge Gergel has indeed made a mistake.
What is your injury?
our injury is we have been engaged in litigation and lost property that they claimed with the aid of the insurance company of Vermont paying their legal fees.
Well, do you make any claim that the insurance company somehow got secret information from you as a client, your people, and gave it to these other people that they represented as a client?
I do not know where. I cannot answer that question.
No, you don't make
That would be an injury.
like
That would be an injury. If they got something from you and then use it against you, that would be a problem.
Here's the thing, Your Honor. Assuming that the South Carolina Supreme Court, in the unlikely event that it says that we lose all our property to the people who have left, we've got a serious injury, and they have contributed to that injury by having all of their legal expenses and other expenses.
It's the good lawyering that you're mad about. They got some good lawyers they could pay for, and based upon those good lawyers, they got property. Is that what you're saying?
Now, what if we're able to prove that the only money they had to pay legal fees with were what they got from our insurance company?
I just really don't get your argument.
Well, the argument is they have contributed to our loss.
But I don't see how. Do you expect them to go without representation?
Well, no, but they wouldn't, if they didn't have any money to pay for lawyers, they couldn't go forward at all.
But no, they would ask from another insurance company. If they weren't insured by your insurance company, they'd be insured by somebody else.
Well, the other, just be given a few seconds. According to the South Carolina Supreme Court, the insurance policy they are using due to the delect of our insurance company, Vermont, that we're trying to bring this action against.
You're over time. If you want to take it up and use your rebuttal, that's fine.
I think, Your Honor, that better stop there and have some time left for rebuttal.
Okay, thank you. Counsel? We're ready to hear from you. Are you muted?
Okay, I'm sorry, I apologize. May it please report, counsel, Melinda Kohlross on behalf of the defendant, Appalachia Church Insurance Company of Vermont. I think you've focused in on the issues. I just want to draw the court's attention to a misstatement that's been repeated several times in Tech's argument. We are not a captive of the Episcopal Church. Church Insurance Company is owned by the Church Pension Fund 100%. That is documented in the record. And so these continued allegations and assertions that we are a captive of the Episcopal Church are wrong.
Explain the difference. Explain the difference. I mean, this captive insurance thing, I'm going to tell you something. Everybody else may have known about it, but I didn't know about it till I got into this case. It's interesting.
Well,
what's the difference here?
A captive insurance company, the difference is it is owned by a parent company, in this instance, the Church Pension Fund, and that Church Pension Fund and its affiliates are the only entities that can be provided insurance by that captive. That's really all it means. The duty to defend, indemnity obligations, those are the same, regardless whether you're dealing with a captive insurer, a mutual insurance company, which is owned by its shareholders, a publicly traded insurance company that anyone can own stock in. The duty to defend, the indemnification obligations are no different. The captive status determines who, from an underwriting perspective, the policies can be issued to in the first instance. There is only one policy year at issue here, which, as Judge Wynn pointed out at the beginning, or asked a question about at the beginning, it is the 2012 policy year. The policy year of 2012, policies were issued to the parishes, some of which disassociated, in October and November of 2012. The policies were validly issued while they were still associated with the Episcopal Church and this diocese. The policies do not disappear. They were in full force and effect at the time of the disassociation. The The issue about duty to defend continues on. It is assessed based upon these underlying actions, and specifically the counterclaims that the diocese brought against the disassociation.
So I'm going to ask you the question that Judge Motz asked your opponent, and that is, if this is in the South Carolina Supreme Court, is there any reason for us to not just wait to hear from them and maybe see if South Carolina Supreme Court will resolve this question, or is that a possibility here?
It is not necessary to do that. They have alleged in their complaint and on appeal, not that the policy gives them the rights that they are arguing about. They're saying it's this trust issue. And currently, the lower court found that they had no trust interest in all this property. So certainly that would knock them out of the box if that lower court decision is upheld. But it is not necessary to affirm Judge Gergel's ruling that there is no standing, because the alleged trust, whatever its character and whether
so translate into what you translate that to me. Translate. Just answer my question. Should we simply wait for the South Carolina Supreme Court to resolve and move with this matter and then determine, or no. Defer?
No, okay, you don't need to wait, because the standing issue, they are insured under a separate policy, and they've continued. The diocese has continued to be insured by Church Insurance Company in 2013, 2014, 2015. The disassociated parishes are no longer insured by Church Insurance Company. The only year at issue is 2012. However, as long as this litigation goes on, the duty to defend does not end at the policy year. If this litigation goes on another 20 years, we're on the hook, unfortunately, to continue with that defense.
We've kind of written cases like that. States have written cases like that. That's why I say the duty to defend is broader than the duty the coverage duty.
Exactly.
And that's the problem you got. And I was wondering who's paying the premium on this thing now. And I didn't think for one moment they were still paying it for the entities there.
You are at 100% right. The duty to defend, much broader. It continues on until the last of these lawsuits are resolved for the counterclaims. We are not funding litigation to affirmatively attack the diocese. There is no coverage under the insurance policy for that. It is a duty to defend. We owe a duty to defend the advertising injury claims that are brought as part of the counterclaims by the diocese against these disassociated parishes. Whether they win or lose those claims is irrelevant to the duty to defend. It is very unusual, in fact, unheard of, to have somebody suing an insurance company for providing a duty to defend. That as long as what you look at to determine the duty to defend, the allegations of the underlying complaint, there are advertising injury allegations in the underlying counterclaims asserted by the diocese. And then you look at the coverage part of our policy from 2012, which is in the record of the underlying case that the disassociated parishes brought against Church Insurance Company, and of which Judge Gergel took judicial notice. Advertising injury is covered under the commercial liability part. There is a duty to defend that says Church Insurance Company has the right and the duty to defend claims potentially covered under the commercial liability part. That's why it doesn't matter if they win or lose. Potentially covered, very broad. It implicates the duty to defend. And the policy further states that the insureds are treated separately. So even if we didn't have individual policies here, which I will get to in a moment, even if the disassociated parishes and the diocese were all together on one policy, the insurance company is charged with the obligation of treating each insured separately. So your question previously, what about the parishes that didn't disassociate? They're covered for the duty to defend. Those that disassociated, as long as the policy was issued while they were associated, we are on the hook for defending them. We're on the hook for defending everyone, unfortunately.
You have a great trial lawyer because you just talk on and on with one breath. I always admire lawyers who do that. Never give the judges a chance to ask the question. Have you ever had this situation before?
Never. I've been doing insurance coverage for 28 years now. Never.
So it's unusual. So you wouldn't no insurance company would voluntarily undertake providing insurance to both sides of litigation.
Certainly not. And, you know, we're stuck providing defense costs for everybody here.
Because there's been this disassociation. At one point, they were all together. And because one group for a period of time, and then as they continued, you didn't represent them. It took several months.
We didn't insure them anymore.
Yes.
Yeah, so we don't insure them anymore, and we didn't once the policies that were properly issued in 2012 expired. There were no renewals. Only the diocese that Mr. Tisdale represents continued with policy renewals. Now, I do want to make sure that you understand factually each.
Well, just to follow up on Judge Moss's point, you know, it is interesting. You are here in an instance where you are defending or you are indicating you should pay. You don't get many insurance company cases to come and do that. Normally you and your opponent would be on the same side, and it would be those disassociated ones coming in saying you should be paying. You say, no, we shouldn't. So you'd be joining forces on it. It's kind of an interesting play of, I guess it's because you've already paid. So it doesn't matter at this point. And you've accepted the responsibility. Once you accept it, I guess, now that I recall, once you accept it, you kind of now have it. So that's where you are. Yeah.
That's 100% right. And even if we assumed it in error, if we didn't owe a duty to defend, if we could have obtained a declaratory judgment determination that we didn't owe it, it doesn't matter. We can't be penalized for doing more than we needed to. As long as there was a potential for coverage.
Are you providing defense? Are you providing something that you had counterclaims against the other side? Are you providing a defense to those?
We're providing a defense to everyone.
So you are paying money on both sides?
Yes. Yes.
And so the injury that which is what I was getting to, the injury here, at least from the mother church, so to speak, of the group, there's no injury. They're getting theirs paid, but they're just mad because you're paying the ones that's fighting against them.
Yes.
But you're paying everybody. You're paying the fees on both sides of this thing.
Yes, we're paying everybody. There is no injury other than, you know, the assertions here that the litigation there would have been different attorneys defending. Well, we don't pick the attorneys. We're just reimbursing the defense costs. In this case,
are all the facts that you're representing to us in this record, or you're just telling this thing outside the record?
No, they are either in the record or they're in the documents of which the district court took judicial notice. There was an insurance coverage action brought by the disassociated parishes against Church Insurance Company. And those documents, the policy, the master policy, the commercial referencing, I do have the cites in our brief to that case number and the docket number and the pages, and have reproduced those. So technically they are not in the joint appendix record in front of you, but they were.
No, they have to be. I'm talking about the record of this case. There was a complaint filed. You never filed an answer, right?
We did file an answer. We did.
Then you moved to dismiss.
No. Well, yes, we moved to dismiss. The issue of standing came up, and then we briefed standing. But we did answer. We did answer the complaint. So I did. Right. Yes, I did want to.
But are you accepting? Are you accepting the allegations of the complaint as true? Mr. Tisdale says you're not.
Only the factual allegations, and most of the allegations. Right. He's trying to impose some obligation that we owe to not defend our disassociated parish insureds. Those are not factual allegations. Those are legal arguments. He is stating that this trust relationship or the captive insurance laws or the corporate charter somehow impose a restriction upon us that we have to pick the diocese as the only entity that we will pay defense costs to, and to abandon the disassociated parishes. And that
in fact is what you're doing going forward. It's just for one piece of 1 year that you're representing both of them.
That's right, but the litigation has had a life of almost
I hear
going on a decade. Judge Motz, I know you're very familiar with the life of the litigation and the circumstances. So unfortunately, we are stuck with that until it is finally over. But no, we do not continue to insure the disassociated parishes because by our charter we can.
And I'll let you talk, but I just want to ask you one more question.
Certainly.
There seems to be sub silencio in the other side's argument, the thought that if you are paying defense costs for one side, there's somehow less money to pay defense costs, or the other side is in some way hurt. Is that a real concern here?
They're not hurt. We didn't tell them that they couldn't get all their defense costs because we're paying somebody else. There's no injury other than the perceived injury that the litigation continues. And the litigation continues because both sides are very entrenched in fighting the litigation.
Well, it looks like you have a conflict of interest if you're paying both sides.
No, there is.
You can only be on one side of the lawsuit.
There's no conflict of interest because we issued separate policies. We issued a policy of insurance, a master policy to the diocese. We issued separate individual policies. This is uncontroverted in the record by the affidavit of the church insurance company officials.
Do you try to tell them how to run their case? You try to tell them what motions to file and what positions to take?
No, they have independent counsel. We're just footing the bill.
Plus, that happens all the time. When
that happens all the time.
Two different groups, and those groups will sue each other, and you have to pay for both of the fees on it.
That happens all the time. So I want to make sure we're clear that those facts are undisputed, and that's
Let me ask you something that I hadn't heard come up. When I asked you about the duty to defend and whether the other side had come, there was a declaratory judgment that was brought, and then you settled it. Who settled it? Was it just between you and these disassociated entities, or was the parent church somehow involved in that settlement?
No. The lawsuit that was brought, well, two lawsuits were brought. The disassociated parishes brought a lawsuit seeking defense
against
church insurance company, and the diocese also, Mr. Tisdale's client, also sued church insurance company in a separate lawsuit seeking their defense costs. So we were sued twice.
Did they seek to intervene in that matter that was brought by the disassociated entity against you? Did the diocese seek to intervene to say, no, you should not be paying their fees?
I don't believe so. We actually tried to get everybody into this action. We moved for joinder to try and bring the disassociated parishes in so we could resolve these issues in one forum. But that motion was denied, and actually Mr. Tisdale's client, the diocese, opposed bringing the disassociated parishes in. His client's position was that they should stay out. His fight was now just with us. I mean, he's got these other fights in the state court with the disassociated parishes, but he wanted this fight to just be between the diocese and church insurance company. And
so you had two lawsuits which really could have been joined.
Yes.
And in my view, probably should have been joined to some, and it would have settled this problem, because then you could have determined, or at least it would have created the issue would have arisen from that problem as to what came out of that. Maybe not a settlement, who knows? I mean, it sounds like to me there was some initial effort that started from the beginning where you've got both entities going against the insurance company. You didn't settle or didn't agree, basically agreed to do it, is what you did.
There was different timing involved. The diocese actually sued us for coverage first, and then with the timing of the counterclaims, then the disassociated parishes sued us second. So then we had these two different lawsuits. But
it wasn't a secret lawsuit. They knew about this lawsuit.
Right.
They were coverage, and so you then settle it. And is the settlement agreement being challenged here, or what is being challenged? You have a settlement agreement. Is that different? Does that now obligate you different from the insurance? Once you settle it, and are we now looking at the policy, or we're looking at the settlement agreement as a basis for your duty to defend?
The only basis for the settlement was the allegations about duty to defend. There's never been any indemnity here. So there was allegations that we owed.
I'm just curious, and maybe I'm just thinking too much on this. I'm thinking, if without the settlement, there is a duty to defend that arises under the contract, and then they bring an action saying you got to, you dispute it, says, no, we don't. Then you settle it. And my question at that point is, now as the insurance company, even if the contract didn't, if they can make a case to say you should be doing in the contract, you've settled and say, I will. And that's not been challenged. So I'm trying to understand, at least from your perspective, why doesn't that duty arise from the settlement agreement that you made to defend?
Because the basis was the insurance policy. So the allegations of their
I got the basis, but I'm giving now that basis has been superseded by now this settlement agreement. You've now agreed to do something to say the insurance company is not ambiguous. The insurance company now requires me to do it. That's a higher type of obligation than the policy itself, which could be challenged to say, I didn't do it. I shouldn't do it. You see where I'm going?
Once we accept the duty to defend, then there's no reason to keep the declaratory judgment action going. We accepted the duty to defend.
But then maybe it wasn't called. Maybe it wasn't a settlement then. Maybe you just accepted the duty to defend.
No,
is that what you're saying?
There was a settlement, but I mean the settlement is confidential, so I don't want to say too much about it. But the allegations are we are continuing to pay their defense costs, to reimburse the defense costs for the counterclaims brought by the diocese.
My final point, and it seems to me, even if the other side prevailed on the argument that the contract doesn't allow you to do so, you've got to do so anyway because you've settled it. You now have a settlement.
Yeah, we have both of those. We have both of those obligations, but the diocese does not have standing to challenge any of that. They're not a party to the settlement agreement. They're not a party to the policies that were issued to the disassociated diocese.
And that position is the one that Judge Gergel took?
Yes, that there is no standing. There's no standing for any of those.
On the specifics that you just recited.
He found that there was no standing for any of the four claims alleged because there was a policy that arguably provided coverage. All we're doing is reimbursing defense costs, and that the diocese does not have standing to challenge our reimbursement of the disassociated parishes' defense costs.
But they said they didn't get any discovery.
They don't.
They should have been entitled to discovery before that was ruled upon.
There's no need for discovery because they have never alleged.
Well, I know you're going to say that because you won, so you're definitely going to say that. But
I would say that because I won.
I don't agree with that at all.
But based on the complaint allegations, they allege that the trust relationship and the corporate charter and captive insurance laws are what give them the rights that they are alleging. The captive insurance laws are not a matter of discovery. Those can be researched without discovery. The corporate charter is already of record in the case, so you don't need any discovery as to that. And the trust relationship does not give one insured the ability to tell its insurance company not to insure somebody else and provide a defense to them in litigation. If I'm insured by State Farm and you're insured by State Farm and you rear-end me, I can't call State Farm and say, I'll be better off in my lawsuit if you don't defend the driver, Judge King, who rear-ended me. I'll be better off. I don't have standing. I don't have a right, regardless of any trust relationship. I can't do that. And that's basically the position that the diocese is taking, that its interests should be placed above those other insureds. And Judge Gergel found there's no standing and there's no discovery needed on that because that's a legal argument. And we don't need discovery on the legal arguments. The facts are in the record and are undisputed.
Thank you very much. You've exceeded your time. Unless my colleagues have any further questions, thank you for your argument.
Thank you for your courtesy.
Mr. Tisdale, do you have any rebuttal?
Your Honor, briefly, thank you very much. just trying to bring this understanding, this situation to a simple understanding. And it is this, that the Episcopal Church in South Carolina, one of its 110 dioceses of the Episcopal Church, is a beneficiary of all the agreements made between the Episcopal Church or the Church Pension Fund and the church and our diocese. And we are allowed to take advantage because of that connection. We are a beneficiary and allowed to see that our damage caused by the church insurance company is addressed. And the only thing we're doing in this lawsuit is to say we have standing to claim that they have hurt us by violating the law. And the law is that they have no chartered right to be financing adversaries of ours in a legal case, and they have no right to support two sides of the coin. So all we're asking for is the right. Now, despite what has been said by our opposition, there is a lot of discovery that needs to be done in this case. We have found out that not only did the coverage not end in 2012, as we were led to believe that it did, we were led to believe that coverage has been renewed and is going on right now. And we believe that we can prove and establish that the existence of that coverage has damaged us. And we
let me ask you about the coverage renewed. I'm confused on that. If we accept it's the 2012 policy at the time and they had a duty to defend, and if they exist that duty to defend continues even after the policy discontinues, you don't make an allegation that they still have coverage for the disassociated entities, do you? Because they're not paying the premium on that. You're paying the premium, right?
Well, we are, because it's our property. They are.
Well, I got that, but they are not paying a premium for that policy. So they don't. In other words, they are not covered by this policy anymore.
Well, we know.
So if they have any duty to defend, it has to arise just under the policy that existed in 2012. Because after 2012, they don't have a policy, from what I understand.
Your Honor, we understand that policy was renewed in 2013. That
How?
Is, we have been told in public papers. We did not know that.
By them?
By them.
They put
So that's
forward in public papers that there was a renewed policy.
Listen to this.
Now that's a little different than providing coverage under this existing policy in ongoing litigation. So litigation might exist in 2020.
They have identified policies that they have renewed, new policies, not the 2012 policy. And it's on page
where is that in the record?
Page 13 in our opening brief.
No. I want the record on it. Where is it in the JA?
The record is pages 52 to 54.
52 to 54.
In the record. And in the case of Church Insurance Company of Vermont, which was Judge Duffy, and that is a South Carolina case. It's I can give you the site on the case. It's 2:15 CV 02590, Judge Duffy, District of South Carolina.
It doesn't matter if the policy was renewed, if a duty to defend exists under 2012. So the only thing that's a contest here is the payment of legal fees from the duty to defend.
Well,
so the fact that they continue to provide a renewal coverage, I'm missing that. Because what I understand is the duty to defend arises under the 2012, and that's a continuing obligation, whether you get a policy or not.
They say they settled all of that in 2015, all issues, including the duty to defend. And they said they paid policy limits, whatever that means. And I think that's the same case which they had to bring a suit for malpractice against their lawyer because he didn't get proper releases. And this thing is, Your Honor, what?
Oh, you're saying that an insurance company can't be on both sides of a lawsuit?
Well, not if
they can't have insureds that are suing each other or that are opposite one another in the lawsuit. But they do it every day, I would in every jurisdiction in the country.
Well, Your Honor, what I'm saying is that they had an obligation by law not to insure people who are not part of the Episcopal Church. Now, that they are violating the law of Vermont and other places if they did that. And
but you haven't filed a complaint against them in the insurance commissioner in Vermont. You haven't complained about that.
Well, they have gotten rid of what they owed, as we have already said, and renewed the policies. And as far as we know, they're going on right now.
Counsel, you are about a minute and a half over. Unless my colleagues have further questions, well, thank you for your argument and take the case under advisement.
Well, we certainly appreciate your attention and listening to us on this matter.
Well, we appreciate having you here. We wish we were in Richmond. We could go down and shake your hand, but we can't do that.
It's more pleasant in Richmond.
Thank you, Your Honor.
I asked the clerk to give us about a 10-minute break before the next case, okay?
So the court will take a 10-minute break.
Will you stay on the line, do we?
Yes, I think so. That's what I'm going to do.
Yes, Judge King. Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Good afternoon. We're happy to your argument to see both of you, friendly faces over again. Mr. Kamen, I think the floor is yours.
And please the court, Jeremy Kamens on behalf of Mr. Corderell Johnson. The double jeopardy clause of the Fifth Amendment protects criminal defendants from being prosecuted twice for the same offense. The clause applies when there's been a resolution on the merits of a charged offense. As the Supreme Court stated in Evans versus Michigan, a merits-related ruling concludes proceedings absolutely. And a primary purpose of the double jeopardy clause is to protect the integrity of such a final judgment. In this case, the district court vacated Mr. Johnson's 924C convictions, not his guilty plea, because the admitted elements are legally insufficient to sustain a conviction. As it said in its order at page 172 of the joint appendix, on the merits, Johnson has established that as set forth in the plea agreement, his convictions for using, carrying, and brandishing a firearm in furtherance of a crime of violence was predicated solely on the conspiracy to commit Hobbs Act robbery charged in count 1. Under Sims, conspiracy to commit Hobbs Act robbery is not a viable crime of violence for conviction under Section 924C. That order constitutes a final judgment on the merits, and the government did not appeal. This case is thus no different from the Supreme Court's decision in Evans, where the trial court directed a verdict on the ground that the state's evidence was legally insufficient to sustain a conviction based upon its erroneous addition of an element of the offense.
Counsel, it seemed to me that United States versus Ford might be a little closer to this case. So maybe you want to talk about it.
Ford is a case which stands for the proposition that if a post-conviction change in the law changes the legal standard of an element, double jeopardy concerns do not preclude the government from retrying the defendant as to the same elements of the offense of conviction. So in Ford, the defendant was originally convicted of 922G, being a felon in possession of a firearm. After this court's decision in Simmons, the government wasn't precluded from retrying the defendant for being a felon in possession of a firearm.
And you think the result would have been different if it had been on a different count?
A different count or a different status. So in 922.
No, I'm just asking the question about a different count. Because that's the distinction you made here. You said that the government was allowed to retry him on the same count with a different predicate. What I'm asking you is if it had been on a different, do you think that the result in Ford would have been different if the government had to retry him on a different count?
Double jeopardy would not have applied if the government sought to recharge or retry him on a different count.
Well, then how is that case any different than this one?
Because in Ford, they were trying him on the same elements in the original charge. So my example in 922G is there are 9 prohibited statuses under 922G. Someone who is an illegal alien can't possess a weapon, or somebody's been convicted in a mental institution, or someone who's a drug user. If in Ford, the post-conviction rule said that the defendant was no longer a felon under any circumstances, and then the government sought to prove that he was a felon because he was an illegal drug user, that would be our case. Because in this case, the government is seeking to substitute an element from the original charge, the predicate offense.
No, I don't think that's quite right, because you set out a predicate that's a little different than what happened here. You said that the government said that he couldn't be charged. I thought you said in your hypothetical that if the court had said you couldn't be charged in any event, you couldn't be convicted for any of this crime, and then you substitute something. Maybe you better give it to me again so that I really understand what you're saying.
So what I mean is that Ford involves a change in the law which altered the definition of an element of the offense. It didn't foreclose the possibility of being convicted on 922G at all for being a felon in possession of a firearm. It said, we are changing the definition. There's this post-conviction rule, in Simmons, the North Carolina law. If the
I know it well.
Okay. But it didn't foreclose the ability of the government to actually prove that the defendant possessed a firearm with the prohibited status as a felon. In fact, that Mr. Ford had other felony convictions. And so In our case, it's different. There is absolutely no way, based on the elements as admitted and provided in the plea agreement, that Mr. Johnson could be convicted of a 924C offense, because the allegation in this case, the ones that were admitted to and specified in the plea agreement, specified a predicate of conspiracy to commit Hobbs Act robbery. There is no way for the government to introduce new evidence to establish that the defendant was actually guilty of 924C based on that predicate. The only thing that the government could do is substitute that predicate for a different predicate. And that is analogous in the 922G context for substituting one prohibited status for another. And we know the government can't do that. We know they can't do that because of this court's decision in United States versus Dunford. In that case, the defendant fell into two of those categories. He was a convicted felon, and he was also convicted of being an unlawful drug user. And this court held that a person who was disqualified because of membership in multiple classes does not thereby commit separate and multiple offenses. So my point is that if the government were to have prosecuted Mr. Dunford in that case for being a felon in possession of a firearm, and then they either got an acquittal or a conviction, the government could not then subsequently come back and prosecute him for being an illegal user of drugs.
Isn't a weak point in your argument is that there was no acquittal here?
There was a determination by the district court on the merits that the defendant, Mr. Johnson, could not be found guilty of 924C.
Because of a change in the law.
That's true. That is absolutely true. But the distinction is not simply
there's been no acquittal, though. You didn't answer Judge Mock's question yet. There was no acquittal.
I think there has been, and it comes down to the distinction that's made clear in Evans versus Michigan. An acquittal means a ruling on the merits, a ruling that resolves culpability, guilt, or innocence based on the charge that the defendant was convicted of.
Well, the substantive offense under the Hobbs Act is different than the conspiracy offense.
Absolutely. And in this case, the defendant was convicted of a predicate offense of conspiracy, not a substantive offense as the predicate. And so if you're looking at whether there has been an acquittal of the 924C in this case, the district
he was convicted of the 924C.
He was convicted
of the 924C. The conspiracy offense was used to show the crime of violence.
That's
and it turns out it wasn't a crime of violence. But the substantive offense is a crime of violence.
All of that is true.
All that's true. And why doesn't Section 3296 of Title 18 take care of this?
3296 relates to charges that were dismissed pursuant to a plea agreement if the plea is vacated on motion of the defendant. So counts 7 and 9 were not dismissed. They were subject to a plea of guilty. The other counts that were in the original indictment were dismissed, but not pursuant to any language in the plea agreement. The plea agreement itself did not require their dismissal. And lastly, 3296 doesn't apply because Mr. Johnson didn't seek to vacate his guilty plea. What he sought was what the district court found, and that is that on the merits, his 924C convictions were invalid. And Evans
Can I just ask you one question? You keep going to on the merits, bless your heart. But I thought acquittals were dispositions as to guilt or innocence.
They are.
There hasn't been any disposition as to guilt or innocence.
It has to refer to the offense of conviction. And so the offense of conviction here is 924C based on the predicate offense of conspiracy to commit Hobbs Act robbery, which is an element, according to this court's opinion in Randall.
But there's not been a determination by anybody that he was guilty or innocent of this conduct. The only determination is that this conduct is no longer a crime, right?
So, Judge Motz, the district court doesn't have to use those words. So in Evans versus Michigan, the district court didn't say there has been an acquittal. It didn't say that. It just said that the government hadn't produced evidence as to an element of the offense. And that is essentially what has happened here, that the admitted
do you argue that your client is innocent?
Of the 924C offense of conviction as specified in the plea agreement, absolutely. he is innocent. He cannot be found guilty because it is not a federal crime. The element or the factual elements of the predicate offense as admitted in the plea agreement do not support the element of being a crime of violence. And
so you're essentially saying he pled guilty to something that's not a crime.
That's correct. Absolutely. He pled guilty.
So if it's not a crime, there's nothing to acquit him of.
Well, I think that the distinction the court is making is that if the district court makes a determination that there's, as a matter of law, that's not an acquittal, and in Evans versus Michigan, that's what the lower court said. Here, the lower court said, this is a question of law. The district court made an error and added an extra element. That's not an acquittal. And the Supreme Court rejected that 8-1. And they said, essentially, what the district court did is made a determination as to culpability, as to the offense of conviction. And that's exactly what the district court did in this case. As defined by what was in the plea agreement, the offenses of conviction and the elements of those offenses include a specified predicate of conspiracy to commit Hobbs Act robbery. And that is not sufficient to satisfy the element of the offense of use or brandishing a firearm during a crime of violence. So you can characterize it as a matter of law. You can characterize it as the admitted elements not supporting the element of 924C, crime of violence. However you want to characterize it, it is a determination that on the merits with respect to the culpability of those offenses, Mr. Johnson cannot be found guilty. And so then the question—
The subsidy of a Hobbs Act offense is a crime of violence.
Absolutely. And he was not found guilty.
And that's—
I'm sorry, Judge King. Go ahead.
No, I didn't mean to interrupt you. I was waiting for you. I'm sorry. Go ahead.
So substantive Hobbs Act robbery is a crime of violence. That is not the offense as specified in the plea agreement to which Mr. Johnson pled guilty. He pled guilty to 924C based solely on conspiracy predicate. And however that is characterized, the district court ruled on—
Which the government characterized as a scrivener's error.
And I think that is an inaccurate characterization, because we know the courts cannot simply switch or pull in and out different predicates. We know that when the government charges an offense and specifies a predicate, or when a defendant pleads guilty to an offense with a specified predicate, that is a critical element of the offense. If the government were to come into a trial and present its evidence of conspiracy to commit Hobbs Act robbery, and the district court were to give it to a jury and then say, no, I can't even give it to a jury because it doesn't support the element of crime of violence, it would be the same thing. It is a directed verdict. There is a distinction, conviction judgment of acquittal, something that is subject to appeal, but it is still based on sufficiency, the sufficiency of the allegation as to the predicate. And once that decision becomes final, either because the government doesn't appeal or because this court affirms a district court's judgment of acquittal that is post-verdict by a jury, then that is subject to the bar of double jeopardy, and the government can't come back.
The indictment had the substantive offense in it.
It did, and for whatever reason, in drafting the plea agreement, the government omitted the substantive offense.
That's right, but that didn't change the indictment.
It did
he
not,
pled guilty to the indictment.
He did not. He pled guilty to what is specified in the plea agreement, and it was certainly the government's prerogative to narrow the allegations in the indictments the same way as if they had charged a 922G offense against someone saying that they're prohibited because they were an illegal drug user and a felon, and then in the plea agreement they drop one of those prohibited statuses. This is exactly that same context, and there's also a Supreme Court case, Sanabria, which is also very analogous, in which the government brought an indictment for an illegal gambling operation. There were two theories of liability, horse betting and numbers betting. The numbers betting was dismissed because of an evidentiary issue. A defendant was convicted because he wasn't involved in horse betting, and the government sought to bring back the charge, the illegal gambling operation, based on the numbers theory. And the court said, no, this is a single offense. And once the defendant was found not guilty of the gambling operation based on the original theory, the government cannot come back with another theory of liability. The same
So,
contact.
I mean, that's materially different, and I understand where you're going with this here. But really, what we're struggling with, or what we're dealing with here, is the issue of an acquittal versus a procedural dismissal. An acquittal occurs when the evidence is insufficient or some other indications indicate that you cannot get criminal liability, even though it's a crime. They didn't present evidence to support the crime, therefore acquittal. That's not what you have here. What you have in the first instance, there's nothing they can produce to support this because it's not a crime at all. And so it fits the procedural dismissal definition to the extent that you have a ruling here that doesn't deal with culpability at all. It deals with a question of, is this in fact a crime? In other words, does it meet a legal standard here? And the answer is no. So it looks like to me, when you look at Ford and you look at cases like Green and others that are here, Teo seems to support it. I think if you look at it in a holistic way, it seems like it doesn't look right that you're being punished because you won. That's really what it comes down to. You went through all this, you won this case, and boom, within an hour, they come back with this. And you said, wait a minute, how you do this? We won. And then you didn't. You didn't win. Well, in fact, you may end up worse than what you were in the whole process. But from a legal perspective, we are sort of hamstrung on this position that there's nothing legally insufficient to support this because there's nothing to support. It's not a crime.
My time is over. May I respond?
Yes.
Judge Wynn, there is no difference between a district court's ruling that the government hasn't presented evidence of a crime, defendant didn't admit to the elements of a crime, and the evidence the government did present was insufficient. The cases that you just mentioned, Tateo and Green, are about procedural fairness, the way that an element was described in a plea colloquy, or in Tateo, the defendant was unfairly coerced into giving a plea that wasn't voluntary. Those are about the fairness of the proceedings that led to conviction. They are not about the viability of a conviction itself. When you get to the viability of a conviction based on the sufficiency of the evidence or whether it is a crime at all, there is a clear distinction between that and procedural fairness. Because Mr. Johnson cannot be found guilty of the 924C based on the conspiracy predicates, he has essentially been found not guilty of that offense.
All right, I think we understand your argument. We'll let the government tell us what they think, and then you have some time for rebuttal.
May it please the court.
Mr. Cook, always a pleasure to see you.
Thank you. It's always a pleasure to see Your Honor.
I bet.
A guilty plea to an offense does not produce an acquittal, and this defendant pleaded guilty. That conviction became final. He then brought a post-conviction challenge that successfully argued that a 924C predicated on conspiracy is not an offense. But that's not a determination of factual insufficiency. You don't say that when somebody did not commit an offense because there is no crime there, that was an acquittal. That's just, he's able to successfully vacate his guilty plea. And then we're left with the question of, does the government have a valid charge that they can pursue? And this court's opinion in Green, I think, is squarely on point and decides this issue. And the defendant's argument essentially boils down to saying Green and the similar case in the trial context, Ford, are abrogated by Evans, which I'll get to in a moment. But in Green, you had a 924C that was premised on pre-Bailey, the idea that the defendant used the firearm. In light of Bailey, we know that use requires active employment. That didn't happen in the case. And so the defendant was able to get his guilty plea vacated because you couldn't base a conviction on having the gun available for use and say that was use in light of Bailey. But the government could rely on the very same indictment or very same language in the indictment that was a re-indictment, that the carry prong was satisfied and that there was no double jeopardy bar. And essentially the same thing is going on here.
Well, but the problem is though that and I kept sort of wondering why this didn't happen, but I finally figured it out. They didn't rely on the same count here. You went to another whole count, correct? Whereas it seems they did in green.
I'm not sure I follow. It's exactly the same indictment.
The same indictment too. Yes,
right.
yes.
We have
there are counts and indictments, right?
Right. So in this case, there's count one, the conspiracy count. Then there's 2 substantive Hobbs Act counts and 2 924C counts.
Right.
Via 18, once the defendant backed out of his, guilty plea and the judge vacated the guilty plea, we moved to reinstate all the charges. And at that point, we then brought back the 924Cs. There's 2 predicates in each of the 924Cs. We are obviously not relying on the conspiracy anymore. So it's just the substantive Hobbs Act robbery. And that's what we're pursuing in the case. And so it's similar to Green insofar as Green, the government originally had a use and carry theory, and it jettisoned the use theory and just went with carry. Essentially the same thing is happening here, except rather than getting rid of a bad use theory, we're getting rid of a bad conspiracy predicate and just.
Help me with Green. Would use and carry the same count?
Yes. So it
used to be that way,
Right. Green dealt with pre-possession with intent, possession and furtherance. So it was use and carry. And I don't think anyone has thought that use and carry create distinct crimes. And so it was a single charge properly there. And on the defendant's theory in this case, the use is the unit of prosecution or possess here. And the predicate doesn't define the unit of prosecution. And so it's exactly the same as in Green. But this unit of prosecution point, I think, is ultimately irrelevant because take a case like Robinson. Robinson was a case where the defendant challenged his 924C after the Supreme Court decided Watson. And Watson concluded that if you hand over drugs and get a gun, you haven't used a gun. And so in Robinson, they said, in light of Watson, you can't government rely on that theory. Robinson then said, well, maybe the distinction between possess and furtherance and use and carry during and relation is 2 different crimes. And so maybe that charge had 2 crimes, that count had two separate crimes charged in it, but it doesn't matter because the result is the same either way. You can rely on, in Robinson in the trial context, the still valid theory that the defendant possessed in furtherance. Likewise here, we can rely on the substantive Hobbs Act robbery. Of course, the defendant can't be convicted on a conspiracy, and indeed taking the conspiracy predicate out of this case eliminates any question about the unit of prosecution because now we have 2 distinct Hobbs Act robberies, 2 distinct uses. There's the M&T Bank robbery and there's the Holiday Inn Express robbery. Under every theory of 924C, those are 2 valid 924Cs, so no duplicity problem. And it's a valid prosecution at this point, and simply vacating the non-crime of a 924C based on conspiracy has no double jeopardy implications that bars.
Now, Mr. Cook, I understand you say, have you re-indicted him?
No, so the way 32.
So what'd you do with the conspiracy language in count 7 and count 9?
So that just would be struck from the indictment, just like.
Has that been done?
Well, as soon as we reinstated the charges.
Hasn't been done.
No, but I mean, that's something that will be done, of course, as the case moves forward.
Right, the government would move to strike certain words from the indictment, which would be the conspiracy to violate the Hobbs Act, and would leave in the substantive Hobbs Act robbery.
Right. And
go forward. And go forward, you're saying we count 7 and 9 and 3 other counts, I believe. There'd be 5 counts against him?
Exactly.
Okay, there's not going to be a superseding indictment again.
No.
Okay, but there'll be an amended or corrected count 7 and count 9.
Right. It would be striking basically functionless language.
Striking the language that's the culprit here.
Right.
Yeah,
that's
what.
Sorry.
Go ahead, Judge.
No, go ahead.
Could you have done this in the first instance? In other words, just include the substantive and the conspiracy in the same time?
So I think I'm not quite following the.
In other words, could you have done what you're doing now in the first instance?
Could you have charged substantive and not conspiracy?
Yes, absolutely.
And why
could you have just put? Why could you put both in there? And the alternative.
Right, and both have. I mean, it's common for 924C indictments to have.
But then you'd have another problem, which is the alternative predicate problem. If you put them both in there and go to trial, and one of them is a lesser offense than the other. Here they weren't a lesser offense at the time you brought the indictment. They were the same offense. They were equal offenses. Right.
I mean, it's
since then, with this Sims case and the Supreme Court case, the conspiracy offense is not a crime of violence anymore, but the substantive Hobbs Act robbery offense is a crime of violence.
Right.
So you wouldn't put that language in an indictment now
exactly.
on 924C because it's not a crime of violence.
I mean, I think it's helpful to think about. Yeah, I think it's helpful.
But their point is, they say that it violates the double jeopardy clause for you to do this. Right. What about that statute that I asked Mr. Kamens about? Whatever it's called, 8276.
3296, Your Honor?
Yes, that's what I'm talking about, 3296.
Right. Essentially,
he says it doesn't apply because his client didn't move to vacate. Or something.
Well, first of all, I would stress, Your Honor, that this is an interlocutory double jeopardy appeal under ABNY. And so questions about the operation of 3296, I think, are not really presented in this appeal. But what 3296, it was properly used. We moved to reinstate it after the district judge.
Well, Judge Hudson relied on it, didn't he?
Yes, he did. And we do too. And we think that was entirely accurate.
Well, that's what I thought. All right.
Right. And so I would say that this is it's functionally similar to, imagine if this case, we had Davis before the defendant pleaded guilty. So the indictment was adjourned, then Davis came down and the government said, we have a problem. We have a conspiracy predicate in there. That's not valid. We would have then removed the conspiracy predicate from the indictment because there's 2 predicates and we don't have to have both in there. And the case would have proceeded and the defendant would have pleaded guilty, presumably, to the 924C with a substantive Hobbs Act robbery. The defendant's argument is because Davis came down after he pleaded guilty, now there's a double jeopardy bar. But that just doesn't make sense in the way that the law treats guilty pleas. Guilty pleas are not, the act of pleading guilty does not trigger an acquittal. And so really what 3296 is doing and what the government is doing here is putting ourselves in the position that we would have been in if we had Davis come down before the defendant pleaded guilty. And we would have sorted out this basically just a inconsequential procedural problem in the context of this case and move forward with the valid substantive Hobbs Act predicates.
So you're presenting a pretty clear. When you made this indictment, you made a choice. You could have charged him under the substantive one or the conspiracy one. And just like an argument, and then it goes up to the Supreme Court, if they don't say it's retroactive, you didn't make that argument, you don't get the benefit of it. I mean, there's a waiver. I know that issue's not here. There seems to be something wrong here. If you make a plea agreement and you don't know, there's nothing that's said, And now when you lose it, you now want the second bite at the apple and says, okay, we could have gone that way. Now we're going to go the other way because we get another shot at it. I mean, aside, I know that double jeopardy is there, but there is something else in that scenario that is distasteful. There's something to say, because we're talking about going through the trial process and the government controls the charge and you choose. You could have done this. It's not like it's something new that it came up. But accepting it, make the choice of which one, and maybe you still could come back and say, well, we chose that one. We come back, since we brought it before it, in all fairness, he has notice of it, we can go back and get the other one. But this only arises because they're successful in indicating it was not a crime of violence sometimes later, not with it. But I'm just curious about that in terms of the fairness of it, that you had this choice from the beginning, that you could have put this there. There's nothing that would have prevented you from doing it. I don't know why you chose the conspiracy as opposed to use that. We'll go back and do the other one.
Right. So I think here's a point that I think may help Your Honor, I hope, on this point, which is in the context of a plea agreement, there's risk assigned by both parties. The way the law works is that the defendant ordinarily, in many situations, would, via the plea agreement, have bargained away future changes in law. Now, we make an exception for this type of claim, and so...
Jurisdiction claim, because it's a crime. It's not a crime. That's the problem I got here. It's not, we make exceptions, but something here, you can't use this or can't do that. But another thing says that's not a crime that he pled guilty to because of the choice that the government made to charge it in that way and to go back to a situation that they could have used in the first instance, which all smells sort of wrong. That you don't get. That's the I got your point, but they don't create the crime. The defendant does not create the risk of the indictment. You do. You into a crime or not. They have to accept it's a crime.
Right. Neither party could have foreseen or did foresee that the Supreme Court was going to validate 924C3B. The defendant's not being held to his failure to foresee that. And the government...
There are instances in which or did not make that objection before the Supreme Court, and had he done it, would have been a whole different ballgame, would have been included. And I know that's a waiver type thing, but it seems to be some kinship here to me that, yeah, you couldn't foresee it, but you got to live with it. If you are the one who made the charge, it's your duty to make the charge. If the Supreme Court comes back and says you didn't charge a charge, how do you then come back and say, well, I'm going to go charge something different?
I mean, respectfully, Your Honor, the points you're making just have no grounding in the double jeopardy clause. But
I understand that. That's why I went somewhere different with it. Did you hear the word waiver come up? Did you hear the connection that you had? There's a constitutional fundamental due process right here that has not really been articulated. I agree with you. We could sit here and talk about double jeopardy. That's a legalistic argument, but beyond that is the Constitution that requires due process of the law. And you don't get to just come in one day and says, I'm going to charge you with this. And then later on, it's not a charge and come back and says, well, I'm going to go with the other one. I mean, do you? I mean, that sounds fundamentally something wrong, but I agree with you. Well, at least I fully understand the double jeopardy thing if we walk that path fully. And I'm not saying we're going to otherwise. I'm just curious. That's all.
Sure. I mean, the double jeopardy issue is the only one before the court. And we don't think that there is any other constitutional impediment to prosecuting the case.
The defendant started out claiming you had breached the plea agreement.
Right.
But you're right. They've abandoned that.
They have, and under Green,
they only come up here on double jeopardy. Pardon?
Right.
Well, can I just say that I also find this a very I think the double jeopardy claim probably doesn't prevail, but the government does have the government has all the cards here. You knew what the crimes were to begin with. Is there a reason why the government, I thought you were on the way to explaining to us why you would just charge conspiracy. Maybe you can explain that to me.
Sure. I mean, I'll give you the explanation. I want to preface it by, I don't think that ultimately it has a bearing on how this case turns out.
I understand what you're saying, yeah.
But how it happened, I mean, is that the first defendant to pleaded guilty with only a conspiracy predicate. That defendant's plea agreement was used as a template, and so the language in the relevant provision referred to conspiracy.
So that's the Scrivener's error,
right? But the district judge said, "Look, I'm not accepting that this was just a Scrivener's error." He still ruled our way. We think that's right. So I think that it really doesn't ultimately matter here.
It doesn't check, but the fact they make a Scrivener's error in the factual statement doesn't change the indictment itself, does it?
It doesn't, and the defendant has admitted both.
Indictment severity, return time to the grand jury.
Right. There's a valid indictment that charges both predicates. The defendant came into court and admitted factually both predicates, and the plea colloquy, to the extent that it delved into predicates, talked about two separate robberies, which would support the idea of there being distinct predicates here. But the key point is, for purposes of procedurally where we are under the double jeopardy clause, the defendant pleaded guilty. He has succeeded in having his plea vacated. There remains a reinstated valid indictment that charges substantive Hobbs Act robbery. And the government at this point can proceed on those charges, which remain valid charges. And the defendant has, essentially the parties have been restored to their original pre-plea positions, with the defendant having gotten the benefit of, now the government's got to prove a robbery from 2009 in 2021, which is not an inconsiderable benefit to the defendant.
So the only reason that you put in the indictment you remember at one point in your argument saying nobody could tell what the Supreme Court was going to do with respect to these conspiracy.
Sure.
Well, we predicted what the Supreme Court was going to do. There was a lot of law around the country. You're an experienced fellow. You read that law. There was a lot of mutterings in the trenches. So it seemed to me that you'd be an extra online or interested in not putting yourself in a position where you'd have what happened here happen.
I think in 2009,
I'm trying to see where, but there's been, what did I say? The last thing to fall. There were these series of cases about conspiracy convictions, right?
Right. In 2009, I think it was a possible argument whether somebody would have stood up in court and said it's likely that the Supreme Court is going to invalidate 924C3B. I think the answer would have been no.
Mm-hmm.
Did you argue the Sims case?
No.
No, he's not from North Carolina.
Oh, I couldn't remember what state it was from.
But again,
I just know he's here a lot.
He's so much.
He has a lot of.
What matters, though, is we have two valid predicates charged in the indictment. The defendant has factually admitted both predicates. The government now wants to proceed on a narrowed theory, and the law permits that. And the fact of pleading guilty does not itself result in an acquittal. And when a court comes out and says that one theory of liability is not a valid theory of liability, that is not an acquittal. That is not a determination of factual innocence. That's just a determination that there is not a valid theory of liability, and there remains the other valid theories here.
So do you stand behind what Judge Hudson did?
Yes. I mean, I'm not sure specifically, do you?
Well, there were a lot of machinations back and forth
Sure.
around this, and so I'm asking you if that's what your position is, what Judge Hudson.
Right. Well, we did challenge his decision to vacate the guilty plea in the first instance because of the factual admissions, but we haven't pursued that appeal. And so as the case comes to this court, it's a done deal now that that plea is vacated.
You actually filed a notice of appeal at one point, didn't you? And then
we
backed off.
We then dismissed it.
Right. So you support Judge Hudson.
Right. At this point, there's nothing that Judge Hudson has done that we disagree with.
Okay. And you don't espouse an alternative theory that I haven't comprehended.
I don't think so. I'm not sure. I mean, if Your Honor had a specific
I just want to know, when we're considering this case, do we consider only what Judge Hudson's rationale is?
Yes, I think that that's right. We agree with that, and our brief tracks it. I mean, and I would add, though, again, that Judge Hudson was adjudicating a series of claims that go well beyond double jeopardy, and double jeopardy is the only thing before this court. So there isn't a need to delve into the contract-based theories in this case from the plea agreement, like the immunity language, because as Green held, the abnate double jeopardy exception for an interlocutory appeal doesn't extend to those issues. So those are issues the defendant would have to raise on an appeal after his
just
conviction.
do that in another day.
Right.
Sometimes I don't understand why lawyers do that. If you think you have a good argument, why not get it resolved?
Oh, I mean,
you would say we don't have jurisdiction because
right. That's the short of it. I mean, the last thing I want to do is see this case last even longer. But we have to adhere to the procedural rules about what there's jurisdiction to adjudicate in an appeal that is interlocutory. I mean, for purposes of how this case comes to this court, it is now, a pre-conviction appeal. The defendant's awaiting trial or a guilty plea.
What is the difference in the sentence? Possible difference in the sentence?
I mean, there's a lot. That'll depend on what the defendant's convicted of at this point.
I understand that, but if he's convicted of what you want to charge him with now, or what it's held that he has been charged with, or however you want to characterize that.
Right. I mean, we're satisfied with the sentence we had, which is why, we would have preferred to just prevail with no habeas relief and go about our business.
Is it 5 and 20? Is that the difference? She asked you a question.
She did.
5 and 20.
He just answered.
He knows better. He received 84 months on the first 924C because it was a discharge, or I'm sorry, a brandishing, and then 300 months on the second one because it was deemed a successive 924C. Of course, I don't think I'm giving away anything by saying there would be a question about whether the First Step Act's changes to the 924C penalties would apply upon a further conviction in this case, but that's for another day. I mean, perhaps the defendant would only be convicted of one 924C. Who knows? But
he would get a conviction under 924C in any event, which he does not have right now.
Right. He pleaded guilty to two 924Cs. Because he's repudiated the plea agreement, he's now facing two 924Cs plus a conspiracy count plus two substantive Hobbs Act robberies. And let me pause and just say, on that point, the defendant doesn't even have a double jeopardy challenge to the Hobbs Act conspiracy and the two substantive Hobbs Act robbery charges that have been reinstated. The thing we're fighting about here is whether we can reinstate the two 924Cs.
Right.
And so
it's only 5, 7, and 9, right?
Right. And I mean, I can say that if he wanted to plead guilty again to two 924Cs, we would take that guilty plea. But if he doesn't want to plead guilty, we're going to trial on everything.
Okay, I understand. Thank you. I've kept you too long.
I'm sorry.
My colleagues have any questions? Okay, we'll hear from.
I'm fine.
Judge King, yeah. Okay. Sir, do you have any rebuttal?
Let me start by saying that we haven't waived any defenses about statute of limitations or the plea agreement. Those are all matters that have to be raised before this court after a final conviction. So they're not before the court now. I agree with
You're only challenging double jeopardy because that's the ABNY jurisdiction, collateral order.
That's absolutely right. Let me disagree with my colleague and friend. Mr. Johnson did not seek to vacate his guilty plea. He continuously characterizes this litigation as about an attempt to vacate the guilty plea and that guilty pleas cannot result in acquittal. The definition of acquittal, or at first, an acquittal can only occur by a jury verdict or a judge's ruling. And the definition of an acquittal depends upon whether the basis for that ruling is substantive or procedural. So in Tateo, one of the government's principal cases, the defendant's conviction was vacated on collateral review. And the court didn't say, well, this is a vacated conviction on collateral review, therefore it can't trigger double jeopardy. No, it looked to the basis for why the conviction was vacated. And it said the conviction was vacated because the defendant was coerced into engaging in a guilty plea. And they said there's no distinction, there's no difference between a procedural unfairness on the road to a jury conviction and a procedural unfairness in a judge twisting a defendant's arm to plead guilty. Those are procedural errors that don't have to do with the substance of the charge. And so what Evans versus Michigan says is that an acquittal encompasses rulings that relate to substance. And this one clearly does. We know that the predicate that was charged in the plea agreement and admitted to is an element of the 924C. This is not a case where the defendant has admitted to elements that the government can completely bring back again and seek the same proof. So in Ford, in Green, in Tateo, the government can bring back the exact same elements, the exact same charge, and try to prosecute the defendant again based on those same elements. That is not possible here because the substantive elements must change. And that's because there was a substantive ruling by the district court in September of 2019 that the defendant could not be found guilty of the 924C convictions. And the reason that is an acquittal is because it is a substantive ruling on the merits. Once you recognize, or once we ask that the court recognizes that distinction, which is squarely set forth in Evans versus Michigan, then it is clear that there is double jeopardy protection to the court's ruling with respect to that 924C decision because it is substantive. The next question is, well, what can the government do? Well, potentially they could on remand bring back the other charges in the indictment if they're not barred by the statute of limitations, if they're not precluded by the plea agreement. Double jeopardy has nothing to say about those other charges. It has everything to say with respect to 924C charges based on the same uses and the same brandishing for which was the absolute basis for the district court's ruling in September of 2019. It is the same 924C in the same sense as in the Ford case, for example. If Mr. Ford had no other felony convictions, Simmons comes out and says that he is not a felon. What could the government do? Could they bring back a 922G and say, well, he may not be a felon, but he's a drug user, and we're going to prosecute him this time for a 922G based on a different status? No, they could not, because Dunford says that those the unit of prosecution is based upon the firearm, the possession of the firearm, and not the status. Well, the exact same case is true with respect to 924C. The unit of prosecution is the use of the firearm. And so when the district court vacates those convictions, that has preclusive effect with respect to other 924Cs based upon that same use or brandishing, because the defendant has been effectively found not guilty of those offenses. You cannot say that that is a procedural ruling or about the procedural fairness. It is because the government, as a substantive matter, created and drafted a document to which the defendant pleaded guilty to an offense that is not a federal crime. That is a substantive ruling, and it is equivalent to an acquittal. And that's why the government cannot bring 7 and 9 back again and resurrect them, because the district court vacated those convictions, and it deserves protection under the double jeopardy clause.
Thank you very much. We appreciate both of your arguments. Good to see you. And we hope to see you next time we see you in Richmond. Thanks very much.
Good to see you all.
Oh. We're happy to have you with us to hear argument in our fourth case, Courthouse News Service versus Schaefer. Also, if you want to, Mr. Matheson.
May it please the court. Good afternoon, Your Honors. My name is Mike Matheson. I represent two independent elected state officials, the clerks of court for the city of Norfolk and County of Prince William, Virginia. Your Honors, this lawsuit has involved a sweeping audit of the efficiency with which these state courts process new civil filings. CNS has sought and won federal supervision of these state courthouses under the auspices of the First Amendment. The systems under scrutiny involve nascent technology initiatives, including systems that are designed and maintained by an independent state agency. Ultimately, the district court concluded that the processing of newly filed civil complaints in these jurisdictions is unconstitutionally slow. Espousing new First Amendment law, the district court concluded that the First Amendment demands that state judiciaries provide contemporaneous access to newly filed civil complaints defined.
Excuse me just a minute. Aren't there a bunch of these cases? This isn't new First Amendment law.
Well, Your Honor, in this circuit, it's new. So there have been 3 circuit court decisions that have dealt with this First Amendment issue. There's the 9th Circuit's decision in Planet. There's the 7th Circuit's decision in CNS v. Brown. And now this court is taking up the issue. There are numerous district court decisions across the country that have grappled with this as well. But the First Amendment issue, Your Honor, I do believe is a case of first impression in this country, at least as it relates between the distinction between the common law and the First Amendment. Firstly, while the 7th Circuit in CNS v. Brown expressed serious doubt about the applicability of the First Amendment, they didn't actually directly address the issue. The 9th Circuit case in CNS v. Planet, it was held there that the Ventura County clerk had waived any argument about the applicability of the common law versus the First Amendment under the law of the case doctrine, because in prior proceedings, that argument hadn't been raised. So the issue regarding whether or not the common law or the First Amendment governs this dispute is not only a matter of first impression in this circuit, but in all federal circuits. So the district court ultimately concluded that the First Amendment demands that state judiciaries provide contemporaneous access to newly filed civil complaints, which was defined.
I don't think that was quite what the ruling was.
Well,
was there a give in the amount of time?
Well, contemporaneous was defined, Your Honor, to mean same day, if practicable, otherwise the next day. And then when that standard was applied to the facts, the court held that there was a threshold percentage of 85 to 90%, which essentially serves as a federally ordained floor on the administrative efficiency of these Virginia state courthouses. I want to, when we're talking about the common law versus the First Amendment, it's important to keep in mind that this case is not a referendum on the common law rule of openness. For many decades, in fact, one court I read said that it predated the U.S. Constitution itself. Virginia law and the federal common law had presumed a right of the public to inspect and copy all judicial records and documents. The clerks are very solicitous of these common law rights. In fact, the district court, according to the district court, the most damaging evidence of an unconstitutional custom or practice was the fact that as soon as the clerks became aware that CNS was dissatisfied with its level of access, CNS reported that the problem was quickly rectified. Thereafter, we proceeded to litigate this case for many months. All the while, CNS conceded that it was receiving everything that it ultimately asked for at trial. Unlike the common law, this court has repeatedly held that the First Amendment guarantees access to judicial proceedings, and specifically judicial proceedings that, quote, adjudicate substantive rights. A necessary corollary is the right to access judicial documents that are sought in connection with those judicial proceedings. At the core of this test is the definition of judicial proceedings itself. This court has held that judicial proceedings are hearings or substitutes for trial. Examples, like in the Rushford case, where a summary judgment motion was deemed to be an adjudication of substantive rights that was a trial-like atmosphere. Or in the criminal realm, in Re Washington Post, this court held that criminal plea hearings, sentencing hearings, or criminal trials are protected by the First Amendment. Most recently in Company Doe versus Public Citizen, this court held that the judicial decisions adjudicating a summary judgment motion were also encompassed within these First Amendment guarantees. A complaint is not a judicial proceeding. Rather, it is the beginning of litigation. The complaint does not adjudicate any substantive rights. In the 2016 opinion, ACLU versus Holder, the Eastern District of Virginia rejected a First Amendment challenge to automatic sealing provisions under the False Claim Act, reasoning that the adversarial process does not even begin until a complaint is served and the defendant files a response. The district court grounded its decision that the First Amendment guarantees access to newly filed civil complaints under the experience and logic test. The experience and logic test has two prongs, the history and the logic prong. The history prong asks whether the place and process has historically been open. And the court concluded, and I quote from page 1495 of the joint appendix, there's no dispute that historically courts have openly provided the press and general public with access to civil complaints. The clerks don't dispute that either, but this is merely a restatement of the common law rule of openness. The touchstone of First Amendment protection is the openness of historically open proceedings and not merely the fact, go ahead.
Thank you. Another litigator can just talk with one breath. So you recognize that the civil complaints fit into the experience and logic test.
Well, Your Honor, I recognize that I don't recognize that civil complaints fit into this experience and logic test. And here's why, because—
I thought you just told us they did.
Well, no, what I said was that the district court concluded that that civil complaints have historically been open, but that is merely a restatement of the common law. That is not what the First Amendment guards against. When the experience and logic test is talking about openness, it's talking about openness of particular judicial proceedings. So let me illustrate by, if we talk about the recent opinion in Company Doe versus Public Citizen, this is a 2014 decision from this court. The harm that is articulated in that case is that due to sweeping redactions and the pseudonymous plaintiff in that case, that, quote, neither the public nor the press was able to monitor the progress of the litigation as it unfolded. This relates to the ability of the public to observe and participate in historically open proceedings, and specifically proceedings that are adjudicating substantive rights. So when we talk about openness, it's the openness of the proceedings themselves and not merely the ability of the public to access documents that's important. And
well, maybe not merely, but why isn't that in the same category, in the same basket of things?
Well, Your Honor, because the court has never articulated a temporal aspect to this First Amendment right. So in the Company Doe versus Public Citizen case, the court said that there is a minimal invasion of the right to access these documents can wreak a First Amendment harm. And of course, when we're talking about the ability of the press to monitor the progress of the litigation, this becomes very important in the context of a summary judgment motion, because if the public is not able to see the sweeping redactions or even identify the party that is suing the CFPB in that case, then there's no ability for the public to consume and understand the proceedings as they're unfolding and happening. What CNS is doing—
access promptly.
Well, I believe that what that reflects is that there's a good reason to require that access to documents be substantially contemporaneous with the occurrence of the proceedings that are at issue in the case. What CNS is doing in this case is they're trying to generalize this principle of law, which is that certain proceedings that adjudicate substantive rights and the documents that are sought in connection with those proceedings, which is a term of art that this court has used repeatedly in the jurisprudence, they're trying to generalize that and say, regardless of whether the documents are being sought in connection with a judicial proceeding, we should be able to observe those documents from the very beginning. And
well, can you explain to me what the harm is in this? The district court took the order that he issued right from the facts of this case. Your client was able to do this.
Yes, Your Honor. Our client was able to meet the
What is
standard.
the harm to your client by ordering your client to do this?
The harm to my client, Your Honor, is that there are momentous issues of federalism and there are momentous ramifications of this decision for the operation of state court clerk's offices across the country. What
are you just litigating this on principle then?
No, Your Honor, we're not litigating this on principle. The court held that we had violated the rights of CNS, and we don't believe that we ever violated the rights of CNS in this case. It was undisputed virtually from the beginning of this litigation that CNS was already getting all of the access that they sought.
Sir, we really do know the facts. In the beginning, they did not get the access. They asked for it. It took 2, 3 months, 4 months, I don't know. But finally they did. But it was because they came in and made a threat of suit, right?
Well, I disagree with that, Your Honor. And the court's justification.
Tell me what happened. It wasn't 2, 3, 4 months that you worked.
Well, according to the district court, it was 2, 3, or 4 months, Your Honor. But there's a couple.
But your facts are different. You have facts on the record that I can turn to that'll show that that was different. That was wrong.
Well, Your Honor, the facts that we would point to in the record relate, first of all, to the sufficiency of the evidence that the court relied upon in making these determinations.
Yeah, but Judge Morgan had a bench trial, and he made findings of fact and conclusions of law. His findings of fact are the facts, unless they're clearly erroneous. He got a trial, and that doesn't happen very often in these cases.
Well, Judge King,
you all litigated this thing, and he wrote it all down, wrote a 50-page opinion. So you have to accept his facts unless you can prove to us or show us that there's clear error.
Well, Your Honor, actually, I believe that on the sufficiency question, the standard of review should be de novo. We made a motion for a judgment as a matter of law at the end of this case.
On sufficiency, I'm talking about his findings of fact and conclusions of law are set forth in that memorandum opinion. And the factual findings are reviewed for clear error, and the conclusions of law are reviewed de novo. That's the standard.
Well, Your Honor, to the extent that, I mean, the case that we're relying on for the idea that a challenge to the sufficiency of the evidence of delays in this case is reviewed de novo is Anderson versus Russell, 712 F3D 865.
I think I'm talking past you, or you're talking past me.
Well, Judge King, if we disagree about the standard of review, then I would.
No, we're not. The evidence is a legal issue. I agree with that. But findings of fact are reviewed for clear error.
Well, Judge King, perhaps I can illustrate where we're coming from on this if I talk about some of the deficiencies that are uncontroverted in the record. I mean, there were not factual disputes that were resolved in CNS's favor. There were things that came out at trial that related to the sufficiency of the data that the judge was relying on, that in our opinion, no reasonable fact finder could conclude that there was sufficient evidence to show that the delays at issue existed here. And just to give one example, the data in this case that the district court ultimately relied upon in conducting its de novo review came from the Office of the Executive Secretary of the Supreme Court of Virginia, which is an independent state agency. And this is machine data that's coming from a system that the clerks use, but it's administered and maintained by the Office of the Executive Secretary. One example, if a filing fee, for instance, if a complaint is filed in the clerk's office on day one, it gets a file stamp. If the filing fee is incorrect, then the clerks don't docket it. And that's under 8.01-331. And all this was brought to the attention of the court. So under 8.01-331, the case is just sitting there. The clerk calls the filer and says, hey, you didn't pay your filing fee, so you've got to come back and fix this. Maybe they come in 2 days, maybe they come in 3 days, maybe they come in 5 days. The evidence at trial, the uncontroverted evidence at trial, was that these problems were widespread. They happen every day. But if you look at the delays, the actual percentage of delays that are expressed in the court's data, they contain perhaps delays that are attributable to the clerk's process, but they also contain delays that are attributable to filing fees. which is a factor that's completely beyond the court's control. Now, the only response from CNS was that this had been presented as a theoretical possibility and that they were unable to quantify it. And the court basically said the same thing. Well, Mr. Matheson, if you're unable to quantify this evidence, then I don't know what you want me to do with it. Well, other than saying that it happens every day, nobody can quantify this evidence. But
Well,
this is
if we decide that this is a matter in which we must determine whether the First Amendment applies under the experience and logic test, do you lose?
No, we don't believe the experience and logic test applies.
I understand you don't believe it, but if we believe it does, then do you lose?
No, Your Honor.
I'm saying you don't believe it. I got you. I understand your point. You say it does not apply. I'll accept you say that.
Yes,
but
Your
if
Honor.
we say it does, do you lose?
No, Your Honor, we don't. I mean, the definition of contemporaneous is at the heart of the First Amendment question. So once we decide the First Amendment applies.
So what do you suggest is the definition of contemporaneous?
Well, I think that contemporaneous, as the court in CNS, as the Seventh Circuit in CNS v. Brown said, in overruling their prior decision in Grove Fresh, I believe that contemporaneous has never been meant in any decision from the Supreme Court of the United States, or certainly not from this court, to be measured in a matter of minutes or hours or even days. So if we look at the court's conclusion, even if we take it at face value that the vast majority of the complaints are being tendered within 3 court days of the initial filing, and even if we look past all of the problems with the sufficiency of the evidence that the court relied upon, I don't believe that those numbers reflect a constitutional violation. As Judge Brinkema said in the ACLU versus Holder decision, Your Honor, the adversarial process does not even begin until the complaint is served and a defendant appears, usually after 21 days, and files a response. Similarly, if we look at the summary judgment motion in the Rushford decision, summary judgment motions are usually filed, and then there's another 14 days followed by another 7 days of briefing before a hearing is even scheduled. The federal court system does not operate in a matter of minutes or hours or days. CNS is only seeking access to this information because they claim that the information is newsworthiness, but newsworthiness alone has never been a higher value that has been adjudicated under the First Amendment. Rather, the court has always relied on the common law. And honestly, the common law standard is the best standard of care you could possibly articulate here, because the common law requires us to look at the reasonableness under the totality of the circumstances. So certainly, if a member of CBS News comes into the clerk's office and says, I want to see a copy of the complaint that was filed in Jane Doe versus John Smith, it would probably be unreasonable not to give that person a copy of that complaint on the spot. But that's not what this case is about. CNS is coming into our courthouses at the very end of the day, and they're saying, show me everything that was filed now. That is a much more onerous request, particularly when maybe the mail didn't arrive until 3 o'clock. Maybe somebody came into the clerk's office at the end of the day and they
Did you tell the district court that? Did you have witnesses saying that this was so onerous you couldn't do it?
We didn't say that it was so onerous that we couldn't do it, but we certainly adduced significant testimony, both from deputy clerks and from the clerks themselves, that talked about what their process was, what time the mail comes in, what time CNS comes in.
Please correct me if I'm wrong on the facts here, but I thought that there was a period of time in which you voluntarily did this.
Your Honor, no, that's not correct.
It's not true. That didn't happen.
What the court held was that there was a voluntary cessation, and we argued under abstention principles, under mootness, or under general equitable principles that this case should have been dismissed. In finding that the case was not moot, Judge Morgan the district court held that there was a voluntary cessation, but there was no evidence of a voluntary cessation. The evidence was that we didn't even know who CNS was until this lawsuit was filed, and that as soon as we were on notice of the fact that they thought that there was a problem, that the problem quickly rectified itself. That doesn't show anything other than good faith on behalf of the
Let me ask you, apparently your time is kind of coming down, but I want to ask, since it seems like to me you're giving a pretty good definition or statement as to what contemporaneous is not. What is it then?
Your Honor,
assuming that the experience and logic test applies, then what would you say is contemporaneous?
Well, Your Honor, I believe that the First Amendment, because it's rooted in the adjudication of substantive rights and the ability to observe proceedings, that immediate and contemporaneous would have to relate to the process in question. So if there's a summary judgment hearing, immediate and contemporaneous wouldn't be 3 weeks after the hearing is concluded. If it's a criminal sentencing hearing, immediate and contemporaneous wouldn't mean 5 days after.
What would immediate and contemporaneous mean insofar as being able to access civil complaints?
Well, Your Honor, I have grappled with this issue at length, and the only standard of care.
Isn't that kind of the issue before us? If we consider that there's experience and logic test that applies, and we say the First Amendment applies, and we have case law here that says contemporaneous, then brings in this whole business, could be an infringement on the First Amendment. So live in that world, is where I'm saying. And then you've told me everything is not with regard to the filing of civil complaints. And I'm simply asking you, since you say Judge Hudson is totally off his rocker. Well, you didn't say those words. I know that because you're more respectful. But you're saying he's not correct on it. And so what then, if we are in that venue of First Amendment on spirits and logic, what then do you say under these circumstances? I'm not talking about all the different proceedings, unless I'm talking about filing the complaints. What's contemporaneous?
I think that the court has two choices. The first choice is that the court draws a bright line, which is what the district court did, which is same day if practicable, and if not, the next day. Or the court can simply do what has always been the common law and say reasonable under the totality of the circumstances. And let me tell you why it is a bad idea for this court to go with the same day if practicable standard, because aside from the momentous issues of federalism and the fact that this is going to usher in an unprecedented era of federal entanglement with state court judiciaries, this court is going to suffocate the ability of the states to implement nascent technologies, to resolve disputes over access to complaints themselves. The federal system has a huge technology advantage over the state courts.
Counsel,
Yes.
you can
You sound like the First Amendment doesn't apply to the state of Virginia.
The First
It's
Amendment.
the supreme law of the land. It's written in the First Amendment. It's written in the Constitution. And Virginia helped write it.
Judge King, we're not contending that the First Amendment doesn't apply and that it's not important. We're saying that it does not attach in this space. It's not triggered by the mere
supreme law of land. That's what the Constitution says.
Well, but Judge King, this court has never said that the mere filing of a document triggers First Amendment scrutiny.
Counsel, you are almost 8 minutes over your time. If you want to continue, this time's coming off your rebuttal time.
No, I would like to reserve the balance of my time. Thank you, Your Honors. I'd like to reserve the balance of my time. Thank you, Your Honors.
Okay, thank you. I'm not sure who goes first.
Mr. William Hipsher.
Yes, happy to hear from you.
Good afternoon, Your Honors. William Hipsher for Courthouse News Service. May it please the court. Courthouse News is a news wire service that provides daily reports on newly filed civil complaints in courts across the country. Its subscribers include lawyers, academics.
Now, you know you're not going to waste your time telling us that, I hope. You know you're not going to give us I know you're not going to give us a history. We got some keen issues we need to get to here.
I had
three
more words.
Go right to it. I'm not trying to cut you off, but I do want you have a limited amount of time. If you spend time on that, this is going to end and we won't get to them. So go right to the issues.
So the issue in this case is, does the First Amendment right of access apply? And the clerks conceded in their first filing below that this court would likely find a First Amendment right of access to newly filed complaints. But now they contend that the First Amendment right of access should not apply until the occurrence of some historically open judicial proceeding in a case, suggesting that the press and public must wait until an actual proceeding. Mr. Matheson even referred to 21 days until an answer is filed. But this court has already extended the First Amendment right of access to complaints filed, yes, in connection with summary judgment filings and summary judgment opinions in Company Doe. But Mr. Matheson did not mention that Company Doe also extended the First Amendment right of access to civil docket sheets, and civil docket sheets are hardly judicial proceedings. The district court here noted that a complaint frames the issues for trial, just as summary judgment is a substitute for trial. And in finding that a First Amendment right of access exists as it applies to complaints, the district court applied both the experience and logic test and the analytical test and found that both were satisfied. And as to the historical availability of complaints to the press, the district court concluded at paragraph 8 of its findings of fact that historically, the press had access to complaints at the end of every day. And the district court also noted that the 9 other federal courts who have considered this issue found a First Amendment right of access to complaints. Now, on timing, the district court followed this court's dictate in Company Doe, which held that where a First Amendment right of access exists, access must be contemporaneous. And Company Doe stated that the public benefits of open proceedings are compromised by delayed disclosure of documents, and then said that each passing day may constitute a separate and cognizable infringement. And this court has not limited its First Amendment access jurisprudence to situations in which a record has been formally sealed. In defining contemporaneous access, the district court first reviewed dictionary definitions of that term, at or near the same time, and then noted that legal news, like other news, has a very short shelf life, and ultimately concluded that contemporaneous access to new complaints needed to be on the day of filing, insofar as practicable, and if not practicable, within one court day, stating that 85 to 90% access would suffice. Now, I want to emphasize that Courthouse News has not sought immediate or instantaneous access or access at the moment of filing, as the clerks repeatedly suggest. What Courthouse News seeks is access by the end of the day of filing, so that it can advise its readers that night, and that is what the district court ordered. As for the clerk's repeated denials—
So what does that mean? What? I don't know if you, can you hear me? Because it sounds like you're breaking up a little bit. Well, okay, because you're breaking up a little bit. Maybe this internet will catch up with us a little bit. It's been a good day so far, but looks like at the end of it, even Judge Motz is beginning to look a little fuzzy here. But
so fuzzy.
I guess when I ask, when you talk about access, we throw those terms around pretty loosely. Technology has come to play in this, and it's not what the founders were dealing with on access, and we're kind of in a different day and age, and yet you give me a textbook definition of access. Tell me again, what are you saying about access in the same day? What does that mean?
What the district court held was that contemporaneous access in this context means that the press and the public were entitled to see newly filed complaints by the end of the day on which they are filed. And he said, where practicable, and he accounted for the possibilities that the clerks raised in the course of the trial. And he said that 85 to 90% access same day would suffice. And significantly, the court noted that over the months between the filing of the complaint and the trial, access in these courts improved dramatically, so that by the time of trial, access in both courts were at 90 and 92%.
Okay, counsel, can I ask you, that's what I understood, but is your submission to us then that all that is required is this 80 to 90% or whatever it is you just told us? Is that what you said to us, sir?
The district court ordered that—
I understand what but is that what your position is now?
That is our position. We are seeking an affirmance of the district court's order.
I understand you're seeking the affirmance, but you keep talking about immediate access and quoting the language that is this day or the next day if necessary. So you don't embroider it with what you just said to us. So that's why I'm I am confused. So I look to you to clarify things for me.
Okay, I may have misspoke, or I may have broken up. What I tried to emphasize is that Courthouse News was not seeking immediate access or access at the moment of filing. Now, to Judge Wynn's point, sorry, Your Honor.
Same day, I thought you said you wanted the same day, or if necessary, the day after. But instead, you think there is the kind of leeway that the district court talked about. Is that correct?
I believe the court provides very little leeway, but some. The court's definition of contemporaneous access is the historical access that the press has had, and that is on the day of filing. By the end of the day, the kind of access that these clerks were able to achieve months after this case was filed. Now,
I do really understand that. Remember, you talked to me just a few minutes ago, you talked to us about 80 to 90%, or they did it within the 90% range after suit was filed. You don't remember any of that?
No, I do remember that. That's exactly what Judge Morgan ordered. Judge Morgan ordered that 85 to 90% of access to newly filed cases on the same day would suffice to meet his contemporaneous access requirement. Now, Judge Wynn, to your point about technology, Judge Morgan also observed that the advent of new technology in courts across the country could have a real impact on this issue. But in the Commonwealth of Virginia, in both of these courts, fewer than 10%, much fewer than 10%, are electronically filed. So we are still dealing with a paper court. And in this paper court, Judge Morgan concluded that contemporaneous access would be allowing the press to see what they have seen in courts across the country for decades, see the cases by the end of the day of filing. And Judge Morgan found that the access improvement in these cases was a significant fact. He observed that access had steadily improved, not within a couple of months, but in the course of the 18 months between the filing of the complaint and the time of trial, access improved from a low of 19% same-day access to 92% in Norfolk, and from 42% to 93% in Prince William. And the court noted that this improvement in access undermined the clerk's general claims of potential disruption if constitutional access was provided. And the clerks admitted that they hired no additional personnel, no procedures were changed during this period, and there was no disruption of their offices. And as to the comment about voluntary cessation, they argue that there was no voluntary cessation of the offending conduct, but they concede in their brief that it was only natural for them to speed up the processing of newly filed cases once the complaint in this action was filed. Now,
is it mandated? I mean, it seems like to me there's been some effort to come together on this, at least in terms of the clerks. There's been articulated some reasons that would indicate, well, we've got some internal problems that's going to make it really difficult for us to comply, and yet they've been undertaking actions to try to meet the requirements here. It just seems to me, I don't know. Is this a one? If we go with the First Amendment and say it applies, and then we try to add, as what was said, a bright line rule on this. Does this apply to a rural county like it does to a metropolitan county? Does that mean that you got different places all over? And for us to articulate a rule that is bright line, is that something you articulate on? I guess I'm going to the contemporaneous issue on this.
Well, Judge Wynn, Judge Morgan addressed that issue and pointed out that the measure of contemporaneous might be different in courts depending on their budgets or staffing or other factors. And so when he said same day where practicable, he was giving the courts some wiggle room. He was not providing a bright line rule. And his ultimate declaratory judgment was informed by the fact that for a number of months prior to trial, the clerk seemed to be able to meet not only his threshold number, but seemed to be able to exceed that. Now, I also want to point out that once the court concluded that Courthouse News met its burden of establishing the substantial delays, the burden shifted to the defendants to offer evidence on their purpose in delaying access, and the district court concluded that the clerks did not provide any evidence at all, either under the strict scrutiny or the intermediate scrutiny standards, that they failed to introduce evidence that their practices were narrowly tailored to serve either a compelling or a substantial interest. Your Honors, the clerks moved to dismiss this case on the grounds of mootness. And we believe that the district court properly exercised its discretion in rejecting the mootness motion, noting that mootness is unavailable when a party quits its offending conduct partway through a litigation.
Well, one of the arguments that you've made is that these delays are attributable to the clerk's practices of processing these claims before making them public. Can you tell me how much the delay is attributable to other factors like incorrect filing or fees or redacting of private information?
Well, Your Honor, incorrect filing fees is an argument that the clerks made before the district court, and the district court considered the contention and rejected it. And it rejected it because the clerks failed to offer any evidence whatsoever that there was even a single filing that was made with an inadequate filing fee on day one that was not corrected until the next day. That is the only circumstance when an inadequate filing would have an impact on the delay calculation. Even their expert relied on the OES filing data without making any modifications whatsoever. And if the clerks felt that this inadequate filing fee had such a huge impact on the delay calculations, they had 18 months after the filing of the complaint before trial to track those delays. They are in complete control of that information, and they could have asked their clerk at the front counter to just record how many times an inadequate filing fee.
If we were to maybe just summarily decide this is something that falls under the First Amendment, you're entitled to these things, is it something that you could work out together as to what that practical, I'm just thinking about it out loud, because you're asking the courts, once we get into that, and always that's a problem. What is contemporaneity? What is access and questions of that nature? You have a goal in terms of obtaining the complaints. They have a goal of doing their job. I don't think there's anything to indicate that they are nefarious in not wanting you to have it. It's basically what they're going to is talking about how practical it is and how much it's going to be a burden on the offices. And maybe, as you say, the budget concerns that were brought up and add more people, that sort of thing. But it seems to me there ought to be something you can work out amongst you if you can get off of the business of whether the common law applies or the First Amendment. If we say First Amendment, and I'm just wondering, is this not something that, and I know it's difficult to ask for parties to, let's just work this out, and rather than having the courts to articulate rules, we then have to formulate, and as you say, apply across the board in a very narrow way.
Well, Your Honor, prior to filing this lawsuit, Courthouse News approached personnel at both courthouses and asked to see specific complaints that had been filed in the course of the day. And in both instances, they were told by supervisory personnel that they could not see complaints until they are fully processed and indexed and scanned and posted on the public access terminals in the courthouse. So we attempted to gain access prior to filing suit, and the district court considered all of that evidence and also considered the relative burdens on the clerks as demonstrated by the fact that they were able to achieve contemporaneous access after this case was filed and That did not disrupt their operations. But the
how do you see them before they're scanned? If you are somewhere in California, you're trying to see a complaint in Virginia. You mean, in all instances, you're talking about your actual presence at that clerk's office. Is that right? Or are you talking about being able to access it at a distance?
The incidents I just mentioned, Your Honor, were our reporter physically going into the courthouse and asking the clerk if they could see specific complaints.
So that I want to be clear on that, because I think the scanning aspect of it seems to me that makes it much more available, in places. And maybe you do want to send a reporter to every one of the clerk's offices in every state to access this. I know you have a financial reason for doing this, but I'm just trying to understand that. Your access is you should be able to walk into the clerk's office and immediately see the complaint filed.
Respectfully, Your Honor, we do not insist on immediately seeing the complaint filed.
Well, let's see it during that day.
By the end of the day. But, Your Honor, we would love to have
But you certainly
access.
aren't talking about one that's filed 5 minutes before the office is closed. I know that.
That's correct, Your Honor. That's why Judge Morgan's statement of the rule, access where practicable, and giving the clerks wiggle room of up to 15% certainly accounts for the case that's filed at the end of the day. As to electronic access in the federal courts, we can see every complaint that's filed in the Eastern District of Virginia online, on Pacer, from any place in the country. But the Commonwealth of Virginia does not provide that kind of electronic access. Hopefully someday it will. Today,
so and then this will kind of disappear once all that happens, right?
As the district court observed, technology may make these issues moot. But what doesn't make this
can
case
I ask
moot?
you,
Yes, Your Honor.
My friend Judge Wynn was trying to maybe broker a settlement. So many times I've been before courts and they've tried to do that.
Not gonna happen.
Well, Judge Morgan tried to broker a settlement before trial and after summary judgment, and suggested the parameters of where he was going and asked the parties to come to an agreement. And that
But
did
understand
not
the brokering I was offering was with some guidance to take off some of the issues off the table and said, this is the world you're in. You're in a First Amendment world. And this is needed, but there's a practical aspect of it is, rather than fight in court, can you get together and says, okay, this is what the clerks can do. This is what we would like. And I don't know, it seems like to me that would be a practical way to do this until the technology gets to the point where you got Pacer and you can pick it up.
Well, with all due respect, Your Honor, that is exactly what Judge Morgan attempted to achieve, and that failed. And so we were put through 18 months of litigation and a 4-day bench trial, following which the district court made evidentiary rulings, findings of fact, and concluded that his concern that the clerks would revert back to their prior practices if he did not issue declaratory relief required him to issue that relief. So I see my time is up. If I may.
Your time is up. I just want to ask you one more question. Are you counsel in these, or your firm counsel in these other cases?
Which other cases, Your Honor?
The other cases representing Courthouse News.
I am counsel.
Litigation like this.
Right. I personally was counsel. My firm has been counsel in many of the Courthouse News cases, but not all.
So it's a veritable, what are the requests for attorney's fees right now in this case?
There is, Your Honor, and there is a separate appeal on the district court's award of attorney's fees.
And what is the amount?
The district court awarded a number somewhat under $2 million in attorney's fees.
And 1.9 million, right?
Right.
Yes, Your Honor.
And your firm was counsel in both the Seventh Circuit and the Ninth Circuit. I see
that is correct, Your Honor.
And you got great big awards there. This is like a gold mine. You just go around the country suing small courthouses, so that all of Judge Wynn's good suggestion that you settle this, you're not interested in settling this, right?
We were Your Honor, we were very interested in settling this before we went to trial on this action and before 18 months of litigation.
Okay, now just a minute. That's a different time. I thought you just told us that Judge Morgan tried to settle things, but I assumed that was after trial. Before trial?
That was before trial, Your Honor.
Sorry?
Your Honor, Judge Morgan tried to settle the case before trial and after the summary judgment ruling.
Oh, well.
And he urged the parties to come to agreement.
Before summary judgment ruling, was there any attempt? In other words, early on, was there any attempt to settle this?
Well, Your Honor, settlement discussions are privileged discussions, but I can say that is my personal practice.
I didn't ask you what they were. I asked you if they took place.
There were efforts to settle the case right at the beginning, and they did not go anywhere, Your Honor. And Your Honor, maybe I shouldn't take exception to—
Both sides were relying extensively on matters of principle, weren't they? Both sides had the principles that they wanted to litigate, and they ended up with $2 million of legal fees to you all, and now litigating in the Fourth Circuit Court of Appeals.
Right. That's going to be, as you said, was somewhat under $2 million. It will be somewhat over $2 million.
Well, Your Honor, I said that was the fee award, but the fact is, as the attorney's fee application lays out, Courthouse News expended far more than $2 million in this case. And quite frankly, my client is proud to bring actions in several courts across the country asserting its First Amendment rights, which fewer media outlets are able to do at this time. So I don't think that Courthouse News or that counsel, quite frankly, should be criticized for bringing cases that have merit and that assert clear rights under the First Amendment to the Constitution.
I wasn't criticizing you. I was trying to identify why you wouldn't settle the case.
Your Honor?
Your point is not a criticism, what you're undertaking, you certainly can do it. But when everything points to an incentive to work it out, I guess it was Deb, do you have that incentive in this? I mean, it's, from what I gave, it was a little bit more than Judge Morgan. I said, what if we actually delineate what the law is? And you don't have to argue that point out. Then you come to a point of, can you work these things out? And I mean, there are cases, and particularly in the civil form, if you make an offer at the beginning from a monetary perspective, and you don't do any better than that, you don't get any. I mean, you don't get any more. That may be something we may need to, at least maybe somebody at Congress or someone needs to deal with, but I guess I'll leave it alone.
If I may just comment on that, Your Honor, there was one Courthouse News case that I handled in the state of Vermont, and we provided the Attorney General of Vermont with a copy of our preliminary injunction papers before we filed them. We said, we would like you to look at the law here. We think we are right. And after 30 days, the state of Vermont agreed with us and changed the particular rule that we were going to oppose in that lawsuit. And my client incurred substantial fees in preparing that case and preparing those preliminary injunction motion papers. And we did not seek an attorney's fee, nor could we, nor did we want to, because that was the appropriate result in that case. In this
Did you attempt that here, sir?
Yes, Your Honor.
Exactly the same thing. You gave them a model complaint.
After the case was filed, I personally attempted it. And before the case was filed, our personnel went to the courthouse and asked for access to these newly filed complaints. And at the time that they were seeking access, there were delays of many days in seeing newly filed civil complaints in these courthouses. So this was something that was attempted and that failed.
Well, we've kept you over your time too. And I know you have a colleague that is going to speak to us, and then we have rebuttal. So we'll have to thank you very much for your.
We also have an amicus, Your Honor.
Yes, I'm listening. I mean, that's what I said, your friend here.
Thank you, Your Honor.
Thank you. Miss Nelson?
Yes, good afternoon, Your Honors, and may it please the court. Jennifer Nelson for amici curiae, the Reporters Committee for Freedom of the Press, and 28 media organizations. Your Honors, I'd like to focus my time today on how important timely access to newly filed civil complaints is from a practical level. As news organizations, amici rely on the contemporaneous right of access to newly filed civil complaints every day to report the news to the media. Some of the amici here are CNS subscribers, including the Associated Press, Gannett, Boston Globe Media Partners, and Sinclair Broadcast Group. This means that CNS is a direct source of information for these news publications. And many other news organizations send their reporters to courthouses on a daily basis to access newly filed civil complaints so that they can report news to the public when it is fresh. As a result, the court's decision today will have a direct impact on the press's ability to obtain contemporaneous access to civil complaints, and therefore on the public's ability to know what's happening in the judicial system. The Supreme Court has recognized timeliness as a fundamental aspect of the news. Freshness and speed are key aspects of reporting, especially in today's fast-paced digital environment. And civil complaints are most newsworthy when they are filed. That's why many CNS subscribers.
So your whole argument is going to first, assuming we're going to accept that this is a First Amendment matter, on which we apply the experience and logic test, and then from a contemporaneity perspective, you are saying that time period should be what? How are you defining that term?
Of course, Your Honor. It is amici's position that contemporaneous means the same day access. And the district court found here that on the same day of filing, insofar as practicable, and if not practicable, within one court day, to allow for certain factual findings that were made during the course of the court.
So no later than the following day after filing, essentially.
It's for purposes of this case, amici supports CNS's position that that's satisfied the First Amendment right of access. And yes, to answer your question, Judge Witt, amici join appellee in emphasizing that every federal court to reach this issue has held, as the district court held below, that the First Amendment right of access applies to civil complaints at the time that they are filed.
And how do you define access?
Of access being able to obtain the original source document, the civil complaint, which
how do you do that?
So it would depend, Your Honor, on how it is filed. In certain of the Virginia courts at issue in this case, where paper filing is still the practice, it involves going to the courthouse and accessing either via the clerk's office or the public terminal the complaint. At the end of the day, as I mentioned, reporters have traditionally gone to clerk's offices all over the country at the end of the day.
Sure. Do you maintain there's any right to be able to access this on the web or through the internet or through any type of electronic means?
Amici certainly supports advances in technology that have allowed.
Not a question of whether you support it. Do you maintain that is one of the requirements? If in other words, if that technology is available, then is it then required to be on the internet, or just what others are doing, just available if you show up and get it?
That is not an issue before this court. To the extent that electronic filing is eventually available, certainly that is an extreme benefit and has greatly increased access to judicial records around the country in the past decades. But for purposes of this case, where paper filing is still proceeding, that access involves access at the courthouse for purposes of this matter, Your Honor.
All right, thank you.
So I'm sorry to tell you that you too have gone over your time, and the time is getting late. Why don't you just conclude with like 2 sentences?
Of course, Your Honor. If I could just make one additional point. The public also benefits tremendously in terms of being able to accurately report to the public when they have access to the original source document, in this case, civil complaints. The media often includes hyperlinks to civil complaints in its reporting when they are filed. And Virginia law actually underscores the desirability of timely access to court records. See,
the only problem I'm having, I think you got a good argument. The reason I went there is that's a good policy argument. Sounds like it'd be good before a congressional hearing. I'm trying to tie it into which legal issue are you making this, other than it's a good idea. Whatever you do is going to be good for the people and it's going to be great. Well, when you're dealing with a legal constitutional issue, sometimes we just have to make it like the law says it is. And that's the only reason I brought it up. I went there to say, how are you tying this in to the legal issue? that's before us.
Of course, Your Honor.
I know that courts write these policy opinions and they got this thoughts who wills, who we're doing a good thing, but we really ought to write them based upon the law.
Well, Judge, of course, and in Company Doe v. Public Citizen, this court held that where the First Amendment right of access attaches, access must be contemporaneous. And of course, we've been grappling with what that term means here today.
Sure.
So I think emphasizing the underlying reasons behind why we are arguing what contemporaneous means, what it means, is critically important to the press's right of access and the public's ability to understand our judicial system.
Thank you very much.
Thank you. Miki, agree with CNS at the court to the firm.
Thank you. Sir, do you have rebuttal?
Yes, Your Honor, and I know we're at the end of the day. I'm going to be very brief here.
Sure
I just, there's a critical piece of the puzzle here that I think is very important for the court to understand. And that is that if you look at the complaint that CNS filed in this case, the complaint was about what CNS calls behind processing access. So they were asking us to change the order in which we were intaking documents into our court system, which we have always maintained is untenable, and it is absolutely untenable. By the time we got to the 30B6 deposition, and this is actually in the record, not the deposition.
When you say untenable, you mean you couldn't do it or was unreasonable? What do you?
We cannot change the order that we do the administrative processing for extremely complex reasons that are beyond the scope of this appeal without adversely affecting the public's access to that information, because we're already doing it as efficiently as we can. So at the 30B6 deposition, the Southeast Regional Bureau Chief for CNS, Ryan Abbott, testified that he was seeking 100% same day. It wasn't until we got to trial where suddenly 85 to 90% was good enough. So for the purposes of the voluntary cessation argument, I think it's important to understand that, and we talked past each other with the district court about this repeatedly, that we never said that we couldn't provide the information as quickly as we were providing it. What we were never willing to do was to completely turn OES's, not the clerks, the Office of the Executive Secretary's system for processing these complaints on its head in order to comply with this 100% same day availability standard of care. So when we get into a voluntary cessation, for purposes of mootness, Your Honors, I'd ask the court to consider the fact that the clerks didn't even know who CNS was before this case was filed. And the evidence was that as soon as we were aware of their complaints, that the problem in CNS's mind, at least according to the position they took at trial, was completely rectified. But that doesn't reflect a voluntary cessation. There's no finding from the district court in this case that the clerks have engaged in any unconstitutional policy. There was never a letter sent to either of these clerks. There was never a meeting with either of these clerks. This is all in the record. So as soon as the clerks find out that they have a problem, and okay, so they go back and they look at their system and they figure out that they're doing things faster. I mean, Judge Morgan used the word prodded. He said that Clerk Schaefer prodded his deputy clerks to work harder to get the complaints done. But that doesn't reflect an unconstitutional customer practice. That reflects that CNS had a grievance with the clerk's office about how quickly they were getting access. And they surreptitiously collected all this data for 6 months without having a single meeting with these clerks. And then they hit us with a lawsuit. And then when the numbers dramatically improve because suddenly we have notice of this issue, the court calls that a voluntary cessation. That's not a cessation.
So what should we do? Send it back to the judge to allow for more discovery and more evidence to be taken by testimony from the clerks in terms of determining this?
No, Your Honor. All of this evidence was in the record at trial. The district court simply disregarded it in reaching the conclusion that the First Amendment had been violated. The only relief that is appropriate here is for this court to enter a judgment for the clerks, reverse the district court's opinion, and to vacate the award of attorney's fees in this case. Either because the First Amendment was not violated, or if the court disagrees, because the contemporaneous standard of care in this case is not a proper statement of the law, because this court is concerned about the momentous federalism problems with the judiciary's entanglement with state court clerk, with the...
Certain issues were certified to us. I don't think that was, isn't that correct?
And Judge Motz, I'm glad you asked that question. We have also filed an appeal as of right. All relief sought in this case has been finally adjudicated. The request for injunctive release was dismissed. Declaratory relief was awarded. The court did retain jurisdiction over the case, but this court has repeatedly said that simply retaining jurisdiction for enforcement purposes does not make a judgment non-final. Indeed, if you look at the record, the only thing—
We have a final order appeal, that's for sure, right?
Yes, Judge King, absolutely. And I believe that puts the issues of the improper venue with respect to Clerk Smith, whose constituency is in Prince William, and she was tried before a Norfolk judge in this case, and the issue of abstention squarely before this court. If you look at the Rule 58 case law, and there was never a separate document objection made in this case, and we're certainly 150 days past the entry of that judgment. But if you look at the Rule 58 case law, this court has repeatedly said that the separate document rule exists to protect appellate rights and litigants' ability to seek appellate review, not as a sword to defeat an appeal that would otherwise be proper. So if this court finds that our notice of appeal is not properly lodged, then the result is going to be that you're going to remand those issues back to the district court, and we're just going to come right back as soon as the court enters a Rule 58 separate document. So I don't see any value in the court declining to review those issues in one appeal. And Your Honors, I really appreciate your time and the extra time that you've given both of the parties in this case. I believe this is an important case. I'm out of time, so you all have a good day. Thank you for your consideration.
Thank you very much. Thank you all.
Thank you.
Wish you good health. Thank you for your time.
Thank you.
I think I'll ask the clerk to adjourn court. And I think the clerk
This
will
honorable
do.
court stand adjourned till tomorrow morning. God save the United States and this honorable court.